very innocuous correction in an order. The matter came up on Friday, where Mr. Jishnu Shah took time, my lord, for the petitioner to seek instructions as to how to secure. The order has recorded that the respondent has taken time. Your lordship recalls Mr. Jishnu Shah was the further petitioner. He had taken some time. Grateful.
I am appearing for the petitioner, my lord, in that matter.
I may have your lordship's leave to mention.
Yeah.
I mentioned this matter, item number 101 and 102 last week. Your lordship indicated that I should mention this week. It was, my lord, was humbly requesting your lordship to fix a date, my lord, the section 9, filed in, my lord, 2024, my lord. It's a foreign award that I have received. Its enforcement is pending. I have filed a post award section 9. If it's a complete, but I have issued notice, my lord.
Not there.
My lord, not there, my
How
lord.
do you issue notice?
My lord, by email.
The client or the lawyers over there?
My lord, to the lawyers, I have issued to the lawyers.
Issue to the client also.
My lord,
Issue to the client also. Nobody's here.
my lord, I will issue to the client. My lordship will.
Mentioning I will not take otherwise unless until the other side is here.
But I am just humbly, I'm not asking your lordship to take up. I will indicate to the client also.
I will list it only when both the sides are there.
My lord, they are the respondent, my lord. I have, with the deepest of respect, my lord, several occasions, your lordship, I have the orders. Your lordship has fixed this matter somehow or the other at their prayer. It could not be taken up, my lord.
Section 9 is being listed. What is the urgency?
My lord, the urgency is that, my lord, I have an award of around 300 crores, my lord. My lord, the enforcement, it's a foreign award, so the enforcement, the execution is pending. Pendency of that, my lord, the execution, my lord, I have filed the section 9. My lord, in the meantime, the
Section 9 is seeking what? You have already
section 9 is for the security of that arbitral
So
sum.
your execution proceedings
My
are
lord,
already there?
execution proceeding under section 47 have to pass the test of 47. There are several judgments of the Delhi High Court and of the Calcutta High Court, my lord, which says that pendency of the execution proceedings, my lord, will not be a bar to file a section 9, and section 9 will be to secure the arbitral sum, the awarded sum, my lord. Well, it's a post award because I have an award, no challenge to that award today till date. My lord, more than 3 years have gone by, my lord. I am only humbly seeking, my lord.
Bring the other side, we'll see.
My lord,
Bring the other side, we'll see. Yes.
I will issue a notice to the client and come back tomorrow, my lord. If they don't appear, lordship will kindly accommodate me then.
One day your client is not going to appear at all.
No, they were appearing. Madam, Mr. Mitra was, Advocate General was appearing.
Yes. What is it?
29 of 2023.
So what petition is it, madam? 34, 9, 29, what is it?
With my lord's leave, my lord, I'm mentioning item number 506 of the monthly list. There is an execution application, my lord. The sum is in question is, I'm mentioning upon notice, my lord, the other side is appearing. The sum in question, my lord, is around 3 crores by now. The only difficulty is, my lord, there was a connected section 34 application, where, my lord, which was being heard. It was at the stage of final hearing, and we undertook, my lord, we will not proceed with the execution till the 34 is heard. Now, my lord, they are not mentioning the 34 also. The 34 is not running in the list. This is the difficulty we are facing, my lord. The petition is facing a deep financial crunch.
Whenever the 34 comes,
But the 34 is not
So
running
have
in the
made a
list, and
statement.
no endeavors have been taken, man, by them to get it listed as well.
between both of
Madam,
you,
may the execution and the 34 matter be taken together, madam.
No,
Taken
sorry.
up together.
nothing, no precedence. Yes.
This matter 506, at least, matter the execution can
When
be
is your
taken.
34 coming?
My lord,
34 is running in the list.
34 is not in the list, and they have not mentioned as well, my lord. They have taken no endeavor to get the 34 listed as well.
Readings are completed, Lordship.
Readings are committee is ready for
Award is
hearing.
of which year?
It was due to be listed on 24th of September 25. Thereafter, it's not been listed. It's appeared
It was mentioned and then
24th
at
September.
least put it in the list. Give the number, the 34 number.
548. I'm so grateful.
Yes.
Item number 1 and 2.
My lords, this is a restoration application, my lords.
Restoration and restoration.
My lords, the fault was of the advocate, my lords, and I really apologize for that, my lords.
Cost of 20,000 also.
My lords, it is a liquidation. The company is in liquidation, my lords. I'm beseeching, my lords, kindly. My lords, had it been the fault of the petitioner, my lords, I would have still agreed, my lords. The money will go out of the pocket of the advocate, my lords.
It should. The way he's handling it, it should.
My lords, there has been change in advocate, my lords, in the GA 1 and 2, my lords, for which the restoration is being sought, my lords. We have been engaged very off lately, my lords, in the month of January only, my lords. We are
The
unable,
other side. Who's on the other side?
my lords, we have served them a copy of the restoration application, my lords.
Where's the service?
So this one.
Where's the report? Where's the tracking report, madam? There's no tracking report here.
My lords, we have served them via email as well, my lords.
Where's the tracking report?
It's not here, my lords.
File it.
We'll file it.
Learned counsel for the. Even with you, things have not changed. Learned counsel for the petitioner seeks and is granted 2 weeks' time.
My lords, this was filed on 10th only, my lords. That is why the tracking report was not available, and it was
They're not served.
sorry, my lords.
They're not served then.
My lords, they
assume-
served. My lords, they are served, but the tracking report we couldn't
Tracking
file.
report has to be there, madam.
Yes,
For me
yes,
to
my
record an
lords.
order.
Yes, my lords.
Learned counsel for the petitioner seeks and is granted 2 weeks' time to effect service upon the respondents. Affidavit of service to be filed on the next date. List after 2 weeks. Same order. Item number 3.
Lord, the settlement is already there. The settlement agreement had been sent to the petitioners, my lord. But
No, Lord, I am opposing, Lord. The matter came up 2 months ago. They have not paid the money, my Lord. Yesterday, on
4 lakhs has been paid, my lord. 1 lakh post-dated check has been here.
they're not giving me a benefit, my Lord. Out of 10 lakhs, I've settled at 5 lakhs. And Lord, this is the 6th month going from the date of the order. I'm running after them for
Lord,
1
the
lakh.
agreement records that
Not
once
charity
the
that they're
agreement,
doing.
once
Just a minute, both of you can't speak at the same time.
Yes.
Lord, the agreement says that once the agreement is signed, 1 lakh rupees will be paid to them. Now they are not signing the agreement. They are saying that once you pay the 1 lakh, then we'll sign the agreement.
That
4
blood-
lakhs has already been paid to them, and it is recorded and it is admitted.
How
There's
much
no
is due now?
1 lakh rupees, and we are also agreeable to give
Oh,
a post-dated
you are-
check.
Lord, let them pay, my Lord. Bad blood has
Every
entered between us. If I sign, he will
You have
not pay.
received 4 lakh rupees.
Yes, my
Yes.
lord.
Do it right now. Where's how you carrying that 1 lakh rupees?
My lord, there's a post-dated check with us, and it's recorded in the agreement also that there will be a post-dated check. Once you sign the agreement,
Lordship
will be paid.
kindly directs, I'll do it today.
Yes, my lord. You may record it in the
Provided
order
they
itself.
provided they hand over the check.
the
Otherwise,
check.
I'll have to run after
Give
them.
the check. Where's the check?
Okay.
And what is the date of the post-dated check? Also, please tell.
It's a October check, my lord. 30th of October check, my lord.
Why is it a post-dated check?
My lord, we had agreed between the parties that once the agreement is signed, we'll be giving them a post-dated
Which
check.
agreement? I have not signed any agreement.
That is the difficulty, my lord. We have the agreement with us. It's written in there that once the agreement is signed, there will be a post-dated check.
So
You will be receiving the
post-dated check, how long? What is
my lord,
the
October.
term of the payment?
October, my lord. 1 lakh rupees, no term. October, one single payment in October.
One
Post-
single payment in
one-
October.
In one single payment in October.
Show me the settlement terms.
My lord, this is a draft of that agreement, my lord. I hope they agree with this right now.
You give a check of a present date and then close the matter. What's the point of giving an October check?
1 second. My lord will kindly look into clause number 1, my lord. Thereafter 2 and 3, my lord, of this agreement.
This is what you have agreed to. What are you saying?
They are not signing.
Lord, I have not signed
This is-
this.
Your client has agreed to these terms and conditions.
They
He
were
has
to
already
pay-
taken 4 lakhs.
Lord, yes, Lord, I have taken
Take
4
the
lakhs.
check,
I'm
sign
taking
the
the check.
agreement.
I'm taking the check, but Lord, there is a high chance that this check will bounce.
We will see that in
Very
October.
well. Your Lordship may kindly then Lord notes that.
Milord will record it, Milord.
Yes.
This is the entire situation. Milord. It was admitted on the
There's no
last.
need to record anything. Come back next week. With
Definitely.
the execution and take the check.
Yes, Lord, I shall take it
Definitely.
today only. I shall take it today only.
Definitely. Grateful.
Keep it for next week for
Grateful.
compliance.
Grateful, Lord.
Next week. Tell your client not to act smart now.
Grateful, Milord.
I to inform I appear for the petition. You know, this is my application for extension of the mandate of the learned arbitrator. The mandate was, once it was extended by this honorable court, my lord, to be found that order at page number 14. But now, my lord, the witness action is going on. Now, there is one more witness that is to be given by the claimant, and thereafter, my lord, the defendants can, the respondents can proceed. I'm praying for, my lord, for 1 year it can be extended. But it can be.
I got the response number 2.
Take down, Ria. The petitioner has filed the present petition under section 29, first paragraph of the for extension of the particular. This court by order dated 24/6/2022 appointed the arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed. Full stop. This court by order dated 21st November 2024 extended the mandate of the tribunal for a period of 1 year. Full stop. Learned counsel for the petitioner submits that witness action, right?
It's going on, my lord. Witness
Witness
action is going on.
action is going on. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the material placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the stage of the arbitral proceedings and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 1 year from today. Full stop. The learned sole arbitrator is requested to conclude the arbitral proceedings and publish the award within the extended time period. With the aforesaid direction, the present application stands.
Grateful, my lord.
My lord, in this matter, I appear for the petitioner, my lord. My lord, apology for appearing virtually. My lord, this is my application for 29A. My lord, the mandate of the arbitrator already expired on 14th July 2025. The extension application has been filed within time. The cross-examination of the last respondent's witness is going on, my lord. This is the second extension.
The first extension was 27
My
July.
lord, the first, my lord, 26 June 2025.
Page.
Page 33 and 34. And I have communicated the order on 14 July 2025.
Take down. First paragraph same over. This court by order dated 27/7/2023 appointed the arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed and with the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months. Full stop. Thereafter, this court by order dated 26/6/2025 extended the mandate of the arbitral tribunal by 1 year till 26/6/2026. Learned counsel for the petitioner states that the matter is at the stage of cross-examination of the respondent's witness. Respondent's witness. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the material placed on record and the argument is advanced by the learned counsel for the party, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 8 months from today.
This is my application, my lord, under section 29A, my lord. I've just prepared a very short list of dates. But the first extension was by consent of the parties, which is recorded in the minutes on 11th of November 2025. The 6 months extension, my lord, expired on 13th of July 2026, my lord. This application was filed within the time, my lord. The matter is at the stage, my lord, where the witnesses are being re-examined on a very limited point, following which there will be final arguments and the matter will be concluded. My lord. The 1 year from the date of pleadings, my lord, stood determined on 13th of January 2026 and 6 months, 13th of July 2026.
This is the first extension.
This is the first extension from this honorable court. But I was humbly praying, my lord, if your lordship, my lord, grants extension for 8 months, my lord, in order to enable the parties to complete the examination and following final arguments. The reason for the delay was, my lord, we have also explained that the honorable arbitrator was been assigned with the duty of the SIR, because of which he could not devote time in the meantime, my lord, because of which the proceedings could not be held.
Thank you. Yeah.
First paragraph, this court by order dated 24th September 2024 appointed the arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 14/1/2025. Full stop. The mandate of the arbitral tribunal was mutually extended for a period of 6 months till 13/7/2026. Full stop. Learned counsel for the petition states that the final arguments.
But examination of witnesses are being also, my lord, being conducted on a very limited point, my lord. Re-examination of the witnesses by consent of the parties, yes.
So this is out at the time of the final arguments, and you started re-examination of the witnesses?
Just before the final arguments, my lord, on certain points, because the evidence was being held by way of questionnaires being exchanged between the parties initially.
It states that re-examination of respondent's witness is being conducted. Full stop. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record and the arguments advanced by the learned counsel for the parties, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceedings and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 8 months.
8 months.
From today.
Deeply obliged. I'm grateful. Grateful.
Item number 7, Your Lordship. This is my application under 29A. The arbitration stands concluded. The matter is reserved. Only the award needs to be passed. I will indicate this is the third extension.
No objectioning is the arbitrator. Only thing is, my lord, last sitting was held on 31st of March. My learned friend did not file his written notes.
There was a delay on our part, but we have filed the written notes.
Now,
Only
I do not object, my lord. I don't know.
How?
I don't object.
Lordship is expressing surprise at Mr. Das not objecting.
My reputation is that I would raise some objection.
I gathered that.
The DAS is there has to be objection. Just give me the dates, please. There was any other extension which was given?
Yes, there were two extensions, Your
Give me
Lordship.
the-
Page 16 and 17.
All right, I got it. There we go. First vehicle, and this court, while order dated 16/3/2023, had appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 13/12/2023. Thereafter, with the consent of the parties, the mandate of the arbiter tribunal was extended for a period of 6 months till 13/6/2025. This court, while order dated 18/6/2025, extended the mandate of the arbitral tribunal for a period of 6 months till 18th December 2025. And further, while order dated 5th January 2026, the mandate was extended for a period of 6 months. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. It is at the stage of final.
Only rendering the award. Rendering the award.
For the parties submit that the proceedings are at the stage of pronouncement of the award. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Having regard to the advanced stage of the proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of
6 months. Your Lordship, as it commends to Your Lordship, I prayed for 6 months.
Why 6
Any
months?
3 months, anything.
I believe, yes, my lord. We have concluded, and my lord, the notes have also been filed.
4 months for a period of 4
Very. I'll communicate. Your Lordship, may I just file the notice of motion and the affidavit of service? Deeply obliged.
I have not filed my wakalatnama in this application, but I have been represented.
I'm deeply obliged.
Much obliged.
Hey.
This is my application under section 29, my lord. This is the first extension, my lord. The arbitrator was appointed under section 14, my lord. So he had started from the evidence.
Where's the order?
Yes, my lord. The order is at page 10, my lord. Subsequently, there is an extension under section 29A3, my lord, and the mandate expired on 4th of July, my lord. 6th July. And the matter is at the stage of evidence, my lord. Cross-examination of my witness, my lord.
It's yet to be concluded.
Yes, yet to be concluded, my lord.
Take down. First paragraph, same order. This court, by order dated 13/11/2024, appointed the arbitrator to adjudicate, had appointed the arbitrator, substituted arbitrator to adjudicate the dispute between the parties. The pleadings were completed with the consent of the party. The mandate was further extended
8 months, my lord.
16/7/2026. Full stop. The learned counsel for the petitioner states that claimant's witness.
Yes, ma'am. Claimant's witness.
Claimant witness is in progress. Full stop. Learned counsel for the respondent states that she has no objection to the extension of the mandate of the arbitral tribunal. Upon consideration of the materials placed on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in adjudicating the by the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceeding and the interest of justice, the mandate is extended further for a period of
8 months, my lord.
8 months.
Once-
Deeply obliged.
Nine.
My lord, this is an application under section 29, my lord. There was an extension, but this is the second extension, my lord. It's at the stage of
Page.
yes, my lord. Yes, yes, page 10, my lord. The appointment order.
Page.
Page 10, appointment, my lord. 36, 38, yes.
Readings are completed.
Yes, pleadings are completed, my lord.
First extension was till
Yes, first extension was given, my lord, for 6 months, my lord. That expired on 4th of July, my lord.
4th of July.
Yes, my lord, 4th of July.
Where's the order?
Yes, my lord. Yes, page 50, my lord.
Riya.
Lordship, the civil revision, Lordship, the order that was passed earlier, 5th of January 2026, Lordship was pleased to record my submissions that civil revision which was filed by the claimant, the petitioner before your Lordship, was in respect to an order passed by the tribunal with respect to production of
I've
certain
recorded that.
documents.
Yes, my lord, it's
Lordship, that
recorded.
civil
Revision has no bearing on the extension of the
Yes,
mandate of the-
yes, my lord. Now, what has happened? The civil revision is still pending, and my client has reasons to believe, Lordship, the award might be passed, and yet the civil revision shall not be disposed of, and the issue will remain open with respect to the stay that has been granted in for production of documents. Lordship will kindly record my submission that the civil revision is still pending. Lordship, in the event that it is not taken up, I shall be coming for an application for extension because I cannot adduce evidence until the documents that was directed to be produced is completed, and the second witness, the claimant, is going
That's
to.
got nothing to do with your
Yes,
civil
sir.
revision, madam.
I understand,
Extension.
Lordship. I'm only
Whatever remedies you have to take in that court.
Lordship, that remedy my learned friend has taken. The civil,
Whatever
they
you
have
have to
taken extension of the interim order.
Yes.
Lordship, there will be there might be a clash of interest, Lordship, when the award attains the finality while the civil revision is still pending. Lordship, in that event, Lordship, I'm only
I've
praying.
already given that
Lordship will kindly.
the order.
Yes, I understand. Lordship will kindly record my submission that I submit that the civil revision is still pending till date.
Same submissions.
My lord, they can file an application also, my lord, if they want to expedite the matter, my lord.
Give, the order है page 50. 50. Same order करो. फिर इसमें ऐड कर देना. जहाँ लिखा हुआ है this court by order dated so and so earlier had extended the mandate वहाँ कर देना. By order dated 5th January 2026, the mandate was extended further for a period of 6 months. Full stop. उसके बाद same.
My lord,
Submission.
my lord, extended for 1 year, my lord. Because they will also give it. They will also
I
give it.
believe my learned friend is yet to put in another witness.
Yes, my lord.
And
Second
thereafter we
witness.
shall adduce.
6 months, we'll give it 8 months.
Very good. I'm grateful.
Very good. Greatly.
My lord, Mr. Sobitpal advocate is sick. He could not come today. I have been requested to make a prayer before your lordship not to take up the matter.
For extension of time, my lord, the hearing has been.
Extension of time.
My lord, I may know he connected with the matter. He may have certain points of arguments. Kindly accommodate, my lord.
Hearing has been
I know,
concluded,
Mr.
my lord.
Sinha, but somebody is not. If you are a member at the bar, what do we do?
No,
Monday
I understand. That's all.
is.
They have
Anyway,
filed their
as your
note
lordship, as your lordship permits.
But I'm not here. Monday.
Monday.
Monday. Grateful, man.
No, 11.
Date, please, your lordship, Lord. I'm appearing on behalf of the petitioner. This is my application for extension of
Your
the
Lordship, we are playing for a not today, Your Lordship.
Why, madam?
Your Lordship, I'm been led by Senior Advocate Devnath Ghosh, Your Lordship.
Where is he?
He's in legs, Your Lordship.
Next door.
There is no objection per se.
In the minutes,
There is no objection.
Any objection to the extension? What are your instructions? She's a junior. Let's not trouble her.
Anyways, we'll come.
Monday. He has no instruction. Only instruction is to take time.
New motion item number 12.
My lord, my application, my lord, concerning renewal of a bank guarantee. My lord,
May
very
please,
short,
my
my lord, application. But if your lordship will kindly have a look at page 83 first. I'm sorry.
So given the quick start, may I submit something? May please, my lord. My lord, what happens in this particular matter, the client concerned is abroad for his treatment. I tried reaching him. I have to file a reply to this, but for that I seek an extension.
My lord, the problem is the bank guarantee will expire. My learned friend will be without security. I only want to migrate my bank guarantee from one bank to another. My lord, that will
If
take
that
about,
is the case, I
take about,
if the bank guarantee is there, I don't have.
that, my
But
lord,
so far as
migrate,
corporate guarantee
We are
is
not getting
concerned,
into corporate guarantee.
my lord, my bank guarantee, my lord,
That is like modification of an order.
modification.
I'm not going to modify the order.
Much obliged, my
Not
lord.
getting into corporate guarantee.
I know. Much obliged, my lord, for
Well,
understanding my predicament.
the last
actually.
bank guarantee, if your lordship will see page 122. My lord, that is all that I'm concerned with. My lord, 122 is, my lord, the last bank guarantee. 3 crores 41 lakhs 88,370. My lord, will see the date of expiry is 25th July 2026.
July
25th July 2026. Date of expiry and date of expiration of claim. Now, my lord, so far as this bank guarantee is concerned, today, my lord, the bank wants 125% margin to renew. Well, other banks are willing to renew it for 100% margin. I just want to migrate it from one bank to the other. Well, this period of migration will take about 8 weeks. Well, I just want that 8 weeks time to put in the fresh bank guarantee. If I cannot, well, then execution will proceed.
I have no objection to that, my lord.
It is subject to furnishing the bank guarantee that the stay of my lord order was made staying the execution of the award. That's all.
Why are you asking for a modification of the order dated?
Kindly do ignore that, my lord. My lord, poorly drafted. I only want liberty to, my lord, to put in a new bank guarantee in place of, my lord, the existing bank guarantee which I had been renewing thus far. That's all.
All right, take down. The petitioner has preferred the present application seeking modification of the order dated 14/7/2022 passed in EC number 213 of 2022 and AP number 424 of 2022, now renumbered as APCOM 268 of 2024 and AP number 477 of 2020. Full stop. Learned senior counsel for the petitioner, Mr. Saha, at the outset states that he is only seeking for extension of the bank guarantee and is not seeking any modification of the order passed by this court in EC 213 of 2022, dated 14/7/2022. Full stop. This court-wide order dated 14/7/2022 had stayed the operation of the arbitral award dated 21/3/2022, subject to the petitioner furnishing a bank guarantee. The petitioner had furnished the bank guarantee on 4/6/2025, which is expiring on 25/7/2026. Full stop. By way of the present application, the petitioner is seeking renewal of the bank guarantee is seeking furnishing of a new bank guarantee in place of the earlier bank guarantee. Full stop. Learned senior counsel for the petitioner states that the bank guarantee is expiring on 25/7/2026. Full stop. In view of the same, he seeks placing of a renewed bank guarantee to comply with the order passed by this court dated 14/7/2022, whereby the petitioner had secured the arbitral award dated 21/3/2022. Full stop. Learned counsel for the respondent states that he has no objection to the renewal of the bank guarantee. Full stop. In view of the same, this court directs this court allows the petitioner to furnish a fresh bank guarantee in terms of the order dated 14/7/2022 within a period of
8 weeks, man.
8 weeks.
8 weeks. That is what the time, that is time it usually takes.
That much time.
I don't want to, my lord, put myself in a situation where the decree will proceed to execution. But within 8 weeks, my lord, I'm instructed that it will definitely.
Guarantee should take hardly 2 weeks time. Not more than 2 weeks, Mr. Saha.
My lord,
there is a question of 8 weeks. Renewal of a
I
bank
do not know, my lord, what time it usually takes, but my lord,
2 weeks. All our orders is 2 weeks.
I'll just kindly.
Not more than 2 weeks.
The format is as per the court.
My lord,
All right,
what
3
we'll do-
weeks.
what we'll do is, my lord,
In general, we give 2 weeks.
my lord, I'll do this, my lord. My lord, I will, my lord, put in, my lord, the entire money, my lord, with your lordship's officer within 2 weeks. And my lord, then the bank guarantee, my lord, will be furnished within 8 weeks. But my lord, till the bank guarantee is furnished, I'll put in, my lord, the entire money as security with your lordship's officer. Kindly appoint any officer. Because I am told that, my lord, the process is, my lord, a little lengthy. It might take, my lord, I am not, my lord, personally aware of how much time it takes. But, my lord, because your lordship has expressed a concern, we'll put in the entire.
Why this will again lead to complication of the order passed earlier by this court. Simple extension is much better than rather
than
it amounts to modification of the earlier order.
What happens, my lord, if I may?
Yes.
What happens? It is the submission in the
I'll give
previous
them
order.
4. I'll give them 4 weeks.
I will not object to that. But my lord, there's one thing before the final order is dictated. I am really suffering since
My lord,
2009 in this matter.
That is your
My
30.
lord, may I do this? Instead of bank guarantee, may I, my lord, furnish this entire money by way of, my lord, fixed deposit in favor of the registrar original site? That is, my lord, better security.
Even that is as per prayer. So it was categorically recorded in the last order by way of which this bank guarantee was furnished that it is as per prayer. So furnishing of the entire amount by way of fixed deposit was also a part of the prayer in the tabulacy.
Whatever, my lord, I want to secure my learned friend, my lord.
So I have no objection to that if the entire
I leave it
money
to
is
your lordship.
deposited
My lord,
by way of a fixed deposit.
I can, my lord, make a fixed deposit in favor of your lordship's officer or the registrar.
That is register original thing.
And how much time will you take for that?
Well, for that, I'll take 2 weeks, 2 to 3 weeks.
But that amounts to modification of the earlier order.
Well, that is why I made a prayer that I don't want to, my lord, press that relief.
Yes. So you do it in 3 weeks' time. This
Very well, my lord. If I have any difficulty with the
come back
registrar's
if you
office,
have
I'll
any.
come back.
Yes.
I'll do it. 3
Uh,
weeks.
Within 3 weeks, subject to the petition depositing the said amount within the stipulated time period, the order of stay, the award shall remain stayed. Award dated 21/3/2022 shall remain stayed. Full stop. Any other direction? Nothing.
No, ma'am.
Shall remain stayed. With the above aforesaid direction, the present application stands disposed of. Yes.
Let the matter be requested for hearing. Pleadings are
Award is of which year?
Well, this
Award is
2022.
2022.
Whenever your lordship wants, but
But
I'm
the year of commencement of arbitration is 2014.
This must be one of those bulky. It will take time.
No. Technically, there are few points which I can understand. My learned senior friend is pressing on the delay point.
Well,
And
there is
the
a point of.
applicability of 29A. I will need 2 judgments, not more than 5 minutes to prove
Well,
my
that
case.
is
So
on
far
the
as the
camera.
remaining part is concerned, I'll just have to highlight.
I have no difficulty. Whenever your lordship's diary permits, kindly my lord put it.
We'll see.
Much obliged.
Great.
Item number 13, my lord. Lordship will recall that the section 17 order, my lord, there was a violation that I am led by Mr. Lakman.
My lord, this is that matter, my lord, where the section 37, my lord, challenging the 37 order.
But is already reserved.
Yes, that's reserved, my lord. And this is one of the contempt which was in connection therewith.
Nothing in this as of today. We'll see that. Give a date in this. The order will come. Your delay.
My lord, within 2 days of their notes, my lord, we filed our supplementary notes.
I think we should have it by next week.
Grateful.
I was just waiting for your comment.
Grateful, my lord.
Just give a date in this. Not next week. Give after 2 weeks. We'll have the final order. Then we'll see if there's any contempt or not.
Yes, my lord. Let us hope there is some. Grateful.
This is that section 11 matter, my lord, public premises and this, my lord. I think.
Yes. So then just refresh my memory.
Yes. So, my lord, this is the subject matter of a sublease granted by the respondent to us. My lord, your lordship will get that.
Have you filed your reply or not?
Everything
Yes, yes, everything. Lordship, the relevant agreement is at page 15. This is the sublease agreement. Yes. Department of Information Technology, Government of West Bengal is the sublessor, and we are the sublessee. And arbitration clause, my lord, is clause 5 at page 28. Yes, clause 5 your lordship has got, my lord?
Yes.
So that is the arbitration clause. Now the sublease was terminated by them on 20th September 2023 at page 67. Allegation of breach of covenant. Then, my lord, we have replied to the notice of termination at page 74, contending that the termination is bad. Then, my lord, there was they initiated a notice under Section 3 of the Public Premises Act, and we filed a Section 9 application before this court, my lord. There was an injunction restraining, my lord, giving effect to that notice. Then the matter went to the division bench. Their appeal was allowed only on the ground of territorial jurisdiction to receive the Section 9 petition. No other point, my lord. Then, my lord, the Section 21, my lord, which we have given, that is at page
120.
Yes, 120. 123 is the tabulation of the dispute. They have replied to the Section 21, contending, my lord, that the Public Premises Act governs the dispute. There can be no arbitration. Then, my lord, we filed the Section 11. I had, my lord, cited 4 judgments. One is the IRCON, that is 25 SCC Online SC, which says that the court Section 11, power of the Section 11 court restricted to see the existence of the arbitration clause. Any further disputes regarding jurisdiction applicability will have to be decided by the arbitrator. It has taken into consideration, my lord, the 7-judge bench of the interplay. Yes, my lord. That is one judgment I have cited. I have cited, my lord, the Central Warehousing Corporation to show that there is no dichotomy, no overlapping. They operate in different fields. And, my lord, two coordinate bench, unreported judgment, where Section 11 was allowed, considering the same act, same act. These were my.
There is a limited question. So far as the two judgments which were learned is citing in support of the proposition, my facts are a little high. They say that so far as also that was my point to start with, I think that there is a conflict between the two acts. They don't operate in different, therefore I can proceed. It is reiterated by the two divisions. Question here is this, whether the lordship has seen the section 21 notice. I am not taking the lordship's time and the reply. Now, whether the intention of the termination is not at page 99 of my affidavit in opposition.
Dikhana. You were supposed to get some judgments also. I'm just asking.
I put
page?
Page 99. Lordship has page 99. Of affidavit in opposition. Does your lordship find it?
That's the last page.
Yes.
Yes.
This is the property which is the subject matter of this.
Yes.
Your lordship will find this is a sale notice for sale of immovable property, auction sale of immovable property for the usual notice. Signing will come to name of the borrower. If you not taken it, Volta Private Limited borrower, guarantor, Volta infrastructure, Volta shares, identity settles. And your lordship can take it from me that the description of the land is the lease. Now, Millard, the question is this. Obviously, Millard, my learned friend has lost its right because he created a mortgage, but that's a dispute that section 11 wrote off but cannot decide. What has happened is, Millard, without my permission, he has taken loan and mortgaged this property without my authority. When the bank wrote to us, Millard, we wrote to the bank immediately saying that we were not authorized. Today, the question is, my learned friend wants to challenge the termination. And Millard, obviously, my remedy would be, Millard, as I have initially.
So, like last time, if I remember correctly, we pointed out it's not only confined to termination, it is also confined to the damages which he seeks.
Yes, right. So
if it was only termination, then your PP Act comes into play. Not PP Act here, it's
West Bengal.
West Bengal.
Yeah. And there is a statute which operates for the and that is not an exception to an arbitrability under the Vitradolia one of them. Person designate, tribunal and a statute.
So that is only to the extent of repossessing.
My difficulty is this, Millard. I have no objection if my learned friend pursues his claim for damages in arbitration. They are separate.
So that's exactly what I was saying.
Yes, but actually, I've clarified that.
No, that has to be decided by the arbitrator.
With respect, Millard.
Arbitrator will have to decide it, Millard.
I can't clarify in section 11.
Well, the thing is this, Millard, I am calling upon your lordship, Millard, to decide the question of arbitrability of the dispute.
Can't do it.
No.
See Vitradolia.
Suppose, Millard, I come.
Arbitrability is also left open.
Yes. Only section which.
What para 71, what are you relying?
Have a look at paragraph 51.
51.
Not onwards, 51 to 50.
Yes.
Both principle of non-arbitrability, has my lord got it?
Yes.
Of non-arbitrability is alluded in the order of reference, which makes reference to Vishmal Kishore Shah, whose decision quotes from Dulabai a case which dealt with the exclusion of jurisdiction of civil courts under section 9 of the Civil Procedure Code. The second condition in Dulabai reads as under, where there is an express bar of jurisdiction of the court and examination of the scheme of the particular act to find the adequacy
and where there is no express exclusion, the examination of the remedies and the scheme of the particular act to find out intendment because necessary and result of inquiry may be decisive. In the latter case, it is necessary to see if the
basically, if I understand correctly, this is only to the extent that the exclusivity or the difference which has been made out or been carved out here is that if a statute provides for a remedy, then arbitrability can be excluded. And it will only be that statute under which the remedy is provided. Suppose there's a KMC Act or there's some other act, and there is a resolution to the dispute under that act, that will take precedence and not really the arbitrability or the arbitration.
That's what I'm trying to also impress upon my lord, is that here is a case where a statute provides for a remedy.
So as far as that is concerned, only repossession or taking over the property, you can say, and that argument can be impressive to that extent that yes, that act will be in that act. But here it is not only confined only to repossession. It is also regarding the damages. They are claiming damages also. If you see the 21 notice also,
it goes to termination and damage.
And damages. And that is where your section 11 opens up. So if we rely on this judgment, is only to the extent that if the statute provides or the statutory remedy which is provided, then in that cases, arbitration can be excluded.
I am not inviting your lordship, my lord, to expressly, if that is the remedy, then expressly exclude arbitration. What I am trying to say is this, my lord, subject to objection, subject to correction, my lord, is that a portion of my learned friend's claim comes within the question of within the four corners of arbitration.
So last time he said he can, as far as termination is concerned, that is something which can be looked into here.
Sorry, Malad. Probably I did not say. I said that the scope of the Public Premises Act starts from unauthorized occupation. It does not decide the validity of the termination. Validity of the termination is kept out of the scope of the Act. Once termination has become final, person is overstaying.
That's right.
The jurisdiction starts.
And the Act says that the moment I gave him a notice, the law presumes that he is unauthorized occupation unless he is given a notice to show cause that because he is in occupation of public land. The principle of law.
I don't want to stop you, Mr. Please tell me. We'll read together.
I'm sorry, Millard, but Millard, I don't need to.
No problem. You
Millard,
make
your lordship has got the point which I'm trying to argue. Millard, that is exactly what I'm trying to argue, that it is a severable dispute. Number one. Number two is this, Millard, as I've already shown, Millard, that my rights have got embroiled, Millard, with the rights of the bank now, which is also not an arbitrable dispute. Because I'll have, so Millard, I have no issues if my learned friend pursues his claim for damages before the arbitrator. But, Millard, I need an observation that so far as the other issues are concerned, I'll be at liberty to proceed, which the judgment which my learned friend side is in support of me, that there are two separate acts operating in two separate fields. The only predicament that the reason why I'm arguing this is, Millard, is that once your lordship says that an arbitrator be appointed in terms of section 21 notice, my learned friend it will be difficult for the arbitrator to say that this dispute has not been referred to me. That is, Millard, I have faced this problem in other arbitrations where, Millard, if the Honorable Court, Millard, following that SBP principle, that once the court says it's arbitrable, then arbitrator is not to say no. And that is the difficulty that I face. That is the difficulty I'm facing. If this observation is there, Millard, thereafter, Millard, I can at least say that it was not the desire of the court or the court had kept it open and on the basis of my submission. Either way.
All these days, all these observations can't come in section 11.
Can't come in a section 11.
This has to be something which has to go before the arbitrator. He will decide these issues. Arbitrability can be decided by the arbitrator. Whether that dispute is arbitrable, not arbitrable, can be decided by the arbitrator.
Millard, it is not, Millard.
That's where you have to, that would be the right forum to pursue.
Yes, but it is not that extreme that once there is an arbitration that seeks the court need not look into
if this court in section 11 makes any kind of observation, that is literally intruding in the domain of the arbitration.
Milord, Milord, with respect, Milord, I'm trying to understand, and an arbitrator has an authority to decide a question. Therefore, his jurisdiction would be governed by the
That is how the law has developed. You know, I mean, initially with the recent judgments, that's exactly what the law is. Krish spinning and all those have really limited the scope of Section 11.
But only that's why I said, Milord, I started by Bidradoli and Booz Allen to show that even the law has developed, but disputes which are clearly non-arbitrable has not been left to the arbitrators. Here we are a situation, Milord, where the dispute involves both. A part of it has become non-arbitrable, a part of it become arbitrable. I could have gone and argued that since the other forum, other than arbitration, would be the right forum because it will finally decide all the disputes between the parties. He can make a claim, I can make a counter claim, the bank can be a party to it, the question of fraud can be decided between him. So that would actually be the forum where it would be panacea to all the problems. All the parties can come because this non-arbitrability issue, Milord, is something, if my learned friend agrees to that bifurcation, otherwise I'll say, Milord, there is a question of non-arbitrability involved. The parties should be referred to a forum where all the issues can be finally adjudicated because the bank's right is admittedly involved. There is a question of fraud, but still fraud can be decided by the arbitrator. And there is a question of a statutory remedy, Milord, which is an admitted position, statutory remedy, and the statutory remedy has proceeded. My learned friend has taken part in it. He is submitted to the jurisdiction, but has filed an application saying that you don't have jurisdiction. And the point which my learned friend is taking, that the statute provides that I am a trespasser to start with, Milord, that is, Milord, the law of the land under the PP Act also, Milord, because you are in occupation of a land belonging to the public. And you cannot use and enjoy it for your purpose. It is not a private land that I'll have go through the rigors of, Milord, the state law and the rent law. So, Milord, in those circumstances, Milord, if we are not at ad idem, Milord, then, Milord, I'll say it's not a not arbitrable dispute.
So this is one of the judgments, and
The judgments of Justice Bhattacharya is squarely on the field. Milord, my learned friend has handed over the judgment of
in Bhagwan Das.
Yes, Milord, Bhagwan Das. Milord, kindly, Milord, see the distinction.
So this you are relying on para 51 to
51 to 53.
Any other paragraph?
No, Milord, your lordship was referring to 71, no?
So basically, it deals with that severance clause.
It's a severable, Milord, non-arbitrable, severable dispute. Number one, which is, Milord, supported by the judgment of Bhagavan Das, Milord, and distinguished. Looking into the facts, Milord, my lord has Bhagavan Das page 4 of that judgment. Milord, looking into the facts of the present case, it is clear that the dispute raised by the petitioner, it is noticed under 21 of the Act, revolves entirely around the allegedly unlawful termination of the concession agreement between the parties and the rights and liabilities flowing from the consent. The dispute resolution under Article 16 of the said agreement clearly covers all disputes. The objection in the present case as to non-arbitrability on the ground of applicable 1962 Act is although attractive at the face value but otherwise specious. The present dispute does not relate to any manner to an eviction proceeding under 62 Act. This is one distinguishing feature. Although collaterally the outcome of the present dispute might affect the fate of the 62 proceeding, the conspicuous of applicability of 62 Act is no manner germane in the present dispute. In the proceeding under the 96 Act, present dispute does not relate to in manner of eviction. Although collaterally the outcome in the proceeding, therefore reference is based entirely, Milord. Lordship can skip over the page and come to the paragraph which starts with undoubtedly. Page 5, bottom.
Yes.
Undoubtedly, the 1962 Act deals with matters under the state list of the 7th schedule of the Constitution, whereas the 1996 Act covers matters within the Union list. Thus, there cannot be any comparison or conflict between the two vis-a-vis present dispute. Since the present dispute has no nexus with the 62 Act, which is a special state act having no operation in the context of the present dispute. As even without going to the question as to the applicable 62, which shall be decided by the appropriate authority, the present dispute at least prima facie pertains to concession agreement and rights relating. This is, Millard, the slightly different from the facts of our case, because here, Millard, the appropriate authority has already exercised jurisdiction, and my learned friend is a party and he has participated. That is one distinguishing feature. And the second distinguishing feature is this, Millard. This judgment also says that the continuation of the arbitration. Here, Millard, 62 Act was not germane because the proceedings had not started. This says that they operate in different field. If they operate in different field and there is a remedy, Millard, there should not be any embargo on me with proceeding. And these are severable issues.
What else?
Millard, this is one. And Millard, so far as Millard, the Debts Recovery Tribunal, I need not trouble your Lordship, Millard, that a dispute between me and the bank cannot go to arbitration, because that again is covered by a proper statute. These are proceedings under the SAPACI Act, which I get rid of. So, Millard, it is absolutely, Millard, either if your Lordship accepts it's severable, then it's okay, both can proceed. If Lordship is accepting that it is not severable, then Millard, I would respectfully submit that if it is not severable and part of it is non-arbitrable, then the party should be left to pursue their remedies before another forum. Where, Millard, his claim under the arbitration for damages or seeking challenge to the termination is not stopped. That is a bigger forum, larger forum, and a forum which will put an end to all disputes. Those would be.
Anything else?
Just kindly see ERCON one paragraph. I think that answers the segregation and bisecting part of the thing.
What do you want me to see? Which one?
Yeah, 2025 ERCON. Kindly see the last paragraph. Para 12.
Yes.
The line starting with, in our view. In our view, therefore, the High Court fell in error in bisecting the claim of the appellant into two parts, one arbitrable, the other not arbitrable, when it found arbitration agreement to be there for settlement of the disputes between the parties. Correct course for the High Court was to leave it open to raise the issue of non-arbitrability of certain claims before the tribunal, which if raised could be considered and decided by it. This, my lord, I think answers the bisection part. Because, my lord, dear Lordship, what my submission is, Lordship sees the scheme of the Public Premises Act. It starts from a declaration of unauthorized occupation. I am not precluded by that act from challenging termination. In the reply to the show cause, if I challenge termination, it is beyond his scope to decide that. So, my lord, this Justice Bhattacharya's order proceeds on that premise.
Yes.
And also, my lord, Justice Sarkar's order. She has, in fact, Justice.
What is your answer to the DRT proceedings?
DRT proceeding, my lord, is not connected with his termination. DRT is taking a separate step against me. He can resist in the section 17 that the land belongs to him. The creation of the mortgage was unlawful. That right he will have under section 17 of the Securitization Act. Any person under section 17 is wide enough to include him, because if it is case that mortgage has been created without his consent. So the DRT, the bank cannot take away his right. That is his remedy before the DRT. But suppose even if he proceeds again in the Public Premises Act, how does it help him insofar as the DRT is concerned? Bank is not a party there. Well, I think that these are my submissions.
But I just forgot one to indicate that I said that the bank is at issue with us. Millard, kindly take note of page 100, our objection to the bank's notice of the affidavit in opposition. I'm sorry, Millard, I missed it. Lord, just one line I'll draw. My Lord, that this is a sum and substance. My Lord, 3rd July is reply to the bank's notice. Kindly come to my Lord, 1st, 2nd, 3rd, 4th paragraph.
Which had
However,
NOC.
the concerned bank disbursed the loan so and so in favor of Rolta Services, which had no NOC by the department to the mortgage the said land. That is the issue with the bank. And the bank's reply to it is at page 105, which Millard says that representations were made as if. Let's give a very long reply. All I need to show to your Lordship Millard that there is a dispute. And in paragraph 11 of that Millard, the bank says, in view of the above, we on behalf of our client call upon your good self that the government of West Bengal to immediately withdraw the aforesaid letter and paper publication, because we made a publication saying that don't deal with the land, dated 4th July, failing which our client shall file appropriate application in the competent civil jurisdiction, including a writ petition. That writ petition has also been filed and is pending before this court. So, Millard, all I wanted to show is this is the nature of the dispute, which involves my learned friends' clients. Deeply.
But only just, I did not show your Lordship the Section 9 order passed in this proceeding. Just your Lordship can make a note of that one. That is in the supplementary affidavit. Dated 10th May 2022. Dated supplementary affidavit filed on 10th May 24 at page 8. And this was the exact contention, and the termination notice was stayed. So there is no proceeding now. They have not revived it. Kindly come to paragraph 14 at page 13 of the supplementary affidavit. Paragraph 14 page just check. Then, my lord, this surface proceedings is also noted at paragraph 17.
But this has been set aside by the division bench.
It has been set aside.
Yes, yes, that has
Not
been
on this ground, only territorial jurisdiction. What I am saying is that after this stay of the notice, there is no further proceeding which has been initiated. After the division bench has held that section 9, this order has been set aside on the ground of territorial jurisdiction. So there is no proceeding when your Lordship is hearing the section 11. And division bench order, my lord, your Lordship will see paragraph 29, which is at page 15 of the second supplementary affidavit. 15 January 26. 15 January 26. Second, এটা কে ফাইল করেছে? তোমাদের আছে 15 January 26 নেই? 10th May আমাদের কাছে তো আছে।
It was 2026.
This is the one.
Kindly come to page 15.
It's the last page of the order.
Yes. Paragraph 29. Since we are of the view that the proceeding under 96 is a suit for land, this honorable court does not, we are not minded to enter into such issue in this appeal. So the observation of the learned single judge that the proceedings are different, the court can exercise jurisdiction and has stated the termination notice, that has not been gone into by the division bench. And after that stay, there is no revival of proceedings. There is no proceeding between the parties as of now, insofar as the Public Premises Act is concerned.
With respect to Mr. Sen Muller, I don't think he is suggesting that an order which has been set aside by a division bench.
No, I'm not saying. I'm saying
on
there
the
is no
ground that the
revival
court
of the
did not
proceeding.
have jurisdiction means that the other observations in the order have any persuasive value.
It's not a question of having for persuasive value. I've given two coordinate pairs.
But this is what I could understand from
No,
what he is right.
persuasive value is 3:1. Obliged. David. Obliged.
15.
My lord, I beg to appear for the petitioner. My lord, my affidavit in reply.
The reply is here.
My lord.
Readings are complete.
Reading has been completed today, Your Lordship.
Yes.
My lord, I'm praying for appointment of an arbitrator in terms of the clause in the memorandum of understanding, which is in page number 17, my lord. And the relevant page is page number 20, clause 9. My lord, may I read out the clause? That in the event of any difference or dispute between the parties herein in connection with, for the purpose of, and in relation to the said land, or arising out of the construction of the present memo of understanding, the same shall be settled and resolved by them mutually, failing which such disputes and differences may be referred to arbitration within the meaning of Arbitration and Conciliation Act 1996. My lord, thereafter, as per the memorandum of understanding, certain sale deeds were executed, my lord. My lord, if I may refer to the sale deeds, which starts in Annexure B, the relevant pages are page number 31. There are 4 sale deeds, my lord. The first sale deed is where the memorandum of understanding has been referred to is page number 31.
So your MOU is referred only in one sale deed or in all the 4?
No, my lord, all the sale deeds. All the sale deeds.
Page 31, yes. What are you showing?
Page 31, 39, 47, and 55. One page number.
Show me what are you reading? Page 31.
Not, there are 2, 3 page numbers. My lord, if I may read out from page number 31 first. And whereas, while seized and possessed of the said property, the vendor company entered into a written memorandum of understanding with the confirming party company herein on 30th day of November 2009. And in terms thereof, the vendor company desired and expressed and agreed to sell and transfer an area of land measuring about 79.05 satak, more fully and particularly described in the schedule written hereunder, to the purchaser company at the mutually agreed amount of consideration of such and such only, and the purchaser company is agreed to purchase the said property. It is also agreed upon by both the parties herein to abide by all the terms and conditions of the said memo of understanding dated 30th November 2009, specially clause number 3 contained therein, and it shall form a part of this instrument.
This is on page 31. Where are you?
My lord,
Second
actually,
paragraph is, it's not.
there are 3 page numbers, my lord, because I think it has been annexed in the lower court as well. My lord, the page number that is marked at the left hand side, right hand side, my lord.
Yes.
Right hand side corner.
There are 3 page numbers here. So which one?
Yes, my lord. I beg your pardon, my lord. My lord, page numbers have not been removed.
Just ask her which one she's relying on. There are 3 numbers. Which one are you relying upon?
For a page.
The one which is marked with the circle?
Yes, my lord, with the circle.
Yes, now
That
tell me.
right before now this indenture witness.
Read it again then. Where are you reading? Read it again.
And whereas while seized and possessed of the said property, now the last third paragraph of the same page before now this indenture witnesses. And whereas, while seized and possessed of the said property, the vendor company entered into a written memo of understanding with the confirming party company herein on 30th day of November 2009. And in terms thereof, the vendor company desired and expressed and agreed to sell and transfer an area of land measuring about 79.05 satak, more fully and particularly described in the schedule written here under to the purchaser company at the mutually agreed amount of consideration of such and such, and the purchaser company is agreed to purchase the said property. It is also agreed upon by both the parties herein to abide by all the terms and conditions of the said memo of understanding dated 30th of November 2009, specially clause number 3 contained therein, and it would form a part of this instrument.
Yes.
My lord, similar clause is there in page number 37 as well. Oh, 37 to one. Okay. My lord, page number 39. I'm
39.
sorry, my lord. Page number 39, the circle portion. This is the second sale deed.
Yes.
The same paragraph. And whereas.
Yes.
Just before, now this indenture witnesseth. Lord, then again, page number. Lord, page number 15.
Page number?
And page number 23.
First page number 15.
15. And the fourth sale deed is page number 23.
Page number 13 is the deed of conveyance.
Yes, it starts from page 13.
Page 15 is
Page 15 is the clause referring to the memo of understanding. Page number.
now not upon one. But this doesn't have that that both the parties agree to the MOU.
Yes,
Yeah,
my lord.
similar clause is there.
Similar clause is there.
Where? Which page?
Page number 15, if I may read out. And whereas, while seized and possessed of the said property, the vendor company entered into a written memo of understanding with the purchaser company herein on 30th day of November 2009, and in terms thereof, the vendor company desired and expressed and agreed to sell and transfer the said property to the purchaser company at the mutually agreed amount of consideration of rupees such and such, and the purchaser company is agreed to purchase the said property.
It's not the same term and condition, madam.
This is bit
Not bit,
different from that of the
entirely
others.
different. If
But
you
but all
read on page 31, it is, see, what is relevant is it is agreed by both the parties hereby to abide by all the terms and conditions of the MOU dated so and so.
Yes, my lord.
So there's an express understanding between both the parties that the MOU dated so and so will be adhered to. But here there's no condition like that in the first
Only
sale deed.
page number 15 clause is different, but page number 23, 31 and 39 and 41 have the same clause.
All right. So two conveyance deed has the same clause.
Page 23 has the same clause as that which I read out in the very beginning. Page 31 has the same clause.
Madam, please.
Again.
Give me clarity. There are 4 sale deeds.
Yes, my
All
lord.
right.
Yes,
The first sale deed which starts from page 13 and that page 15 which you read out doesn't have any, it is only a indication of the MOU. But
My lord,
there's
and
no
on the
argument.
basis of that MOU, this property
That's
has
right.
been sold. Yes, ma'am.
But in that, the clause is differently mentioned. It has been differently worded in that clause. Then the second agreement starts from page.
Starts from page 29
Page
and
29.
31.
And your
MOU is referred to page number 31.
all right, these two are different. Then you have
This one is the same. It is agreed upon by both the parties to abide by all the terms and conditions of the MOU. Thereafter, page 39 has the same clause.
just a minute.
Page number 15, 15, 23. Nine.
How many conveyance deed are there?
Lordship, I believe
Four.
four. I'm on a
But page
different
numbering
print.
is completely
Messed up, Your Lordship. It's
neither here nor there.
Numbers. And I'm absolutely sorry, my lord. I beg your apology, my lord.
Completely messed up page number. How do you?
Lord, actually, now I could realize that the middle page number is the correct page number.
it's difficult for me to follow as well.
Yeah.
Which is in ink?
My lord.
Which is in ink? That middle page number is the correct page number.
Yes, my lord. My lord, as per
The ink
the
one.
because as per the petition, it ends at page number 16, and the annexure A MOU starts at page number 17. Lord, if I go by the correct page number, if I may again, my lord, refer to the correct page numbers. The first sale deed where the MOU has been referred is page number 31. My lord, the middle page number.
Yes. This is the first sale deed, right?
Yes, my lord.
All right.
The second one is page number 39. Third one is 47, my lord. And the fourth one is 55.
So only the first one doesn't have it. The second, third.
The second, third, and fourth have the same clause.
Yes. What else?
My lord, and I have submitted one mutual terms of settlement earlier, but now when I have submitted the reply, I have annexed that settlement clause in the reply. If I may refer to that, my lord.
Page.
My lord, there are two affidavit of replies filed. That I have just submitted, my lord. My lord, the first affidavit in reply, which has been filed against the affidavit in opposition filed by the respondent number 1, where in page number 11, the minutes of the meeting has been annexed, my lord.
That is only expression of settlement of dispute out of court.
Yes, my lord. We have tried to settle the dispute amicably, but it has failed, and thereafter, the parties have indicated that they could not do anything because they have already sold that portion of the property which was supposed to be handed over to us as per the MOU for the ingress and egress of the petitioner, my lord. And those properties have already been sold in the year 2021. And my lord, I have not yet obtained the certified copies to whom they have sold, because I was not aware of the parties to whom they have sold. But presently, in spite of an injunction order which has been obtained from the court below, my lord, they are going on constructing in the property, my lord. And my lord, there might be, and my lord, my learned friend may refer to the word may in the arbitration clause, where it says that it may be referred. So there is a discretion, my lord. But all the facts and circumstances of the case, starting from filing of section 9 till date, my lord, there have always been an understanding that the clause, the dispute resolution clause, has been followed, and they have particularly cooperated in every field. They have tried to settle the disputes amicably as well, my lord. And when there is an express arbitration clause, my lord, I pray to your lordship that this may be referred to an arbitrator instead of going before a civil court, my lord. But for that, if I may refer to a Supreme Court judgment as well with a similar arbitration clause in that. 2018 9 SCC 774. My lord, in the second page, the dispute resolution clause that they had was, in the second page, point number 4, paragraph 4. The dispute handling, common processing contract disputes, the parties should be settled through consultation. Consultation fails by treatment of to the arbitration body for arbitration or to the court. There was also a choice to the parties to go before either to the arbitrator or before the court. My lord, and if I may refer to the last page of this judgment, page number 10, ultimately this case was handed over to an arbitrator. If I may read out, my lord. In the case at hand, as we find, clause 15 refers to arbitration or court. Thus, there is an option and the petitioner has invoked the arbitration clause. And therefore, we have no hesitation in the obtaining factual matrix of the case for appointment of an arbitrator. And accordingly, Justice Prakash Prabhakar Naulekar, formerly a judge of this court, is appointed as sole arbitrator to arbitrate upon the disputes which have arisen between the parties. The learned arbitrator shall be guided by the Arbitration and Conciliation Amendment Act 2015. The learned arbitrator shall make positive efforts to complete the arbitration proceedings as per the 2015 Act. Lord, that's all I may submit.
Yes.
Your lordship takes up the cause title of the section 11. The petitioner is Desire Agro. The respondents are 1, Ashiana Vinimay Private Limited, and 2 is Streamline Distributors and Management Private Limited. Now, if your lordship comes to page 17 of the application, which is the memo of understanding dated 30th of November 2009, lordship will find that the agreement, the memorandum of understanding is between Ashiana Vinimay, which is the respondent number 1, and Desire Agro, that is the petitioner before your lordship. The respondent number 2 is not even a party to the arbitration agreement. So the respondent number 2 at the outset was
Just a minute,
at the outset is not a party to the arbitration agreement and cannot be bound by it. Now, if your lordship takes up the arbitration clause itself, page 20, clause 9, that in the event of any difference or dispute between the parties herein in connection with or the purpose of and in relation to the said land or arising out of construction of the present memo of understanding, the same shall be settled and resolved by themselves mutually, failing which such disputes or differences may be referred to arbitration within the meaning of Arbitration and Conciliation Act 1996. Your lordship, the word used here is may. So it is not a binding arbitration clause. The parties may or may not choose to go to arbitration. Lordship, this is my second point. First is that respondent number 2 is not a party. 2, the arbitration agreement is not a binding agreement. Lordship, my third point, I'll place the case law. I'll just indicate my points. The third point is that this agreement is already barred by laws of limitation. Kindly takes up the date of the memorandum of understanding. This is 30th of November 2009. At page 17, your lordship will find 30th of November 2009. Now, if your lordship, the various deeds that my learned friend has placed, if your lordship kindly takes up, these are all unexecuted deeds. Kindly takes up page 29 at page 30 where the agreement has been, where the 31 where the clause has been referred to. If your lordship comes to page 35 of that application, there is no sign of either of the parties. Page 35, your lordship will find none of the parties have signed. So your lordship, similarly, if your lordships will see page 37 of the application, this is again a deed of conveyance which has not been executed by the parties. Your lordship will find at page 43 of that application, none of the parties have signed this agreement. Similarly, for the rest of the two deeds, your lordship, I can show. Page 45 is the next deed. Page 51, your lordship will find nobody has signed this agreement. Now, your lordship will kindly take the pleadings what they have taken for extension of the period of limitation. Your lordship kindly takes up paragraph 12. That your petitioner states that due to inconvenience in egress and egress to the petitioner land, the petitioner on several occasions and lastly on 6th of August 2024 had requested the respondent number 1 for construction of road as it was agreed by the said memo of understanding dated 30th of November 2009, but the respondent number 1 neglected and failed to comply request of your petitioner by way of not responding the request of the petitioner. Rather, the respondent number 1 was trying to dispose of and or sell and or constructing structures over the land to be used for the purpose of construction. So, lordship, the last cause of action that is pleaded is 6th of August 2024, which is not a written request. It's an oral request that they are relying. The only previous document that they are trying to rely on are deeds of conveyance which are unexecuted, or maybe probably a draft, not even executed. So there's no written acknowledgement or written communication between the parties till the issuance of the notice under section 21. The other request is also oral. Now, your lordship, may I just show two case laws to show that this arbitration agreement is not a binding arbitration agreement. Your lordship, I'll just summarize the 3 points. R2 is not a party, limitation, and not a binding arbitration clause. Here, your lordship will find the clause was at page 2, paragraph 4. The clause has been set out here. The lessor, in inverted commas, the lessor shall be bound to renew the lease for subsequent periods of the same tenure if such option is exercised by the lessee. The rent and other terms and conditions shall be mutually agreed, and if not agreed upon, the same may be decided by an arbitrator to be appointed by the parties. Lordship, almost identical from the arbitration clause in question before your lordship. Now your lordship will kindly take up paragraph 7. The use of the expression may indicates that the parties had agreed that in future the parties may approach the arbitrator for settlement of disputes. The use of the expression may is a possibility and not a binding agreement. The meeting of minds of the parties to refer such dispute to arbitration is not available from the clause itself. Not only must an arbitration clause indicate that the parties had agreed that they shall refer the disputes to arbitration, but the clause should also indicate that the parties agreed to refer the dispute to a private tribunal and would be bound by the decision of the said tribunal. Accordingly, the use of the expression may in the clause clearly indicates that the parties had not decided to refer their disputes to arbitration, but had kept an option open that in case of disputes not being settled, the parties would have an opportunity to approach an arbitrator for adjudication of the disputes. This is not a binding arbitration clause. The use of the word may denotes a discretion and is typically non-binding. Thereafter, if your lordship comes to paragraph, your lordship, thereafter a host of case laws are referred to. I'll just come to the concluding portion at paragraph 13. The petitioner may have exercised such right by issuing a notice, but the respondent did not accept such suggestion, which itself shows that the parties did not agree to go to arbitration. So another judgment on the same point of a coordinate bench. Here also, Your Lordship, it was an application under Section 11, Paragraph 1. Paragraph 3, Your Lordship, the same point was taken. Learned counsel appearing for the respondent takes a point of maintainability of the present application on the ground that there is no arbitration agreement between the parties. Clause 5 is the arbitration agreement. If Your Lordship kindly comes to the set out portion, last paragraph, right above paragraph 6. In case of parties other than government agencies, the redressal of the dispute may be sought through Arbitration and Conciliation Act as amended by the Amendment Act of 2015. Here also, Your Lordship, the use of the word may in the arbitration clause was interpreted. Kindly takes up paragraph 7. The point which arises for consideration is whether the part of the clause containing the word may can be construed to be an arbitration agreement as contemplated under Section 7 of the 1996 Act. Section 7(1) defines an arbitration agreement to mean an agreement by the parties to submit disputes which have arisen between them in respect of a defined legal relationship to arbitration. The section includes non-contractual relationships. Section 7(2) envisages agreements which are embedded in the contract or in the form of a separate agreement, and Section 7(3) stipulates that the arbitration agreement must be in writing. Section 7(4) factors in 3 situations where the arbitration agreement will be accepted to be in writing, and Section 7(5) looks at the arbitration agreements being incorporated by reference. Section 7 underscores the unequivocal intent of the parties to go to arbitration by giving shape and form to the arbitration agreement and exit options to the parties under subsection 4 and 5 of Section 7. Presence of the word may in the arbitration clause in the matter at hand is required to be tested against mindset of the parties to the agreement. Parties consenting to arbitration, including to the mode and mechanism of the procedure, forms the mainstay of the 1996 Act. Thus may negate the existence of an arbitration agreement. In Jagdish Chandra versus Ramesh Chandra, the Supreme Court set out 4 broad principles on what would constitute an arbitration agreement. These are the intent of the parties to enter into an arbitration agreement as discernible from the terms of the agreement. Absence of the words arbitration or arbitral tribunal would not be fatal to the existence of an arbitration clause if the clause has the attributes or the elements of an arbitration agreement. The clause must provide that the disputes shall be referred to arbitration in the event of disputes arising between the parties. Mere use of the words arbitration or arbitrator in a clause will not make an arbitration agreement if the clause requires further consent of the parties for reference to arbitration. These principles in my humble submission apply, because here also merely by using the words arbitrator or arbitration does not mean the parties had entered into a binding arbitration agreement. Thereafter, Your Lordship, paragraph 12, Jagdish Chandra is discussed further, masterfully encapsulates the parameters of what constitutes an arbitration agreement, and more important, the party's intention to arbitrate. The will to arbitrate must clearly be articulated in the arbitration clause. There is no room for any doubt or second guessing. Parties must be clear in their minds that they wish to subject themselves to arbitration as the chosen mechanism of dispute resolution and ensure that the intention is expressed in writing in the form of the arbitration agreement. Your Lordship thereafter kindly takes up paragraph 14. In fact, Your Lordship kindly takes up paragraph 13 also. There are some examples given. The clarity of intention should hence be expressed through clear-cut words. Therefore, words such as the parties wish, or the parties will consider, or the parties will therefore decide, and the parties may, will be counterproductive to the unequivocality of the intention to arbitrate. The above instances are not exhaustive and may include other words which give a sense of indecision, lack of purpose, pre-verification, or even saving the option of for arbitration to a later date or as a last resort. So thereafter, paragraph 14, an arbitration agreement also does not sit comfortably with conditions attached for the parties to go to arbitration. The clause should not be subject to or conditional upon further or future events which may or may not occur. In essence, there cannot be any ifs and buts on an undecided mumble. The parties give a resounding yes to arbitration. For a movement analogy, the arbitration agreement is not about a hesitant one step ahead and two step backward or backtracking, but a confident one-way stride to forward to arbitration. Section 11 of the Act is one of the earlier interventions by a court on the presumption of the existence of an arbitration clause. The court must hence ensure the existence of an arbitration agreement before flagging off the road to the award and beyond. The parties cannot set forth on the procedural journey if there is no arbitration agreement. In the present case, the arbitration agreement muddies the water with regard to the immediate and unequivocal reference of the dispute to arbitration. The word may in the relevant part of the clause gives an option to the parties to either refer the dispute to arbitration or to hold back on the arbitration. The word may makes the clause conditional on a future event or to the other parts of the clause and gives the parties the option to resile from the clause. In other words, the clause creates a Hamlet-esque hand on the chin indecision, and the court is also left wondering as to what the parties actually intended. Lordship, ultimately in this matter also, the matter was not referred to arbitration. So here, Your Lordship, the arbitration agreement itself is not a binding arbitration agreement. The word used may itself shows that the parties may or may not go to arbitration. Those are my three submissions. Limitation also have shown, Your Lordship, those deed of conveyance are not executed. The only pleading in the application is of August 2024, whereas the memorandum of understanding is of 2009. Nothing in between to show that the cause of action has been extended as
all these conveyance data of 2010, right?
Your Lordship. The memorandum of understanding is of 2009. The
2009, the conveyance deeds.
Conveyance dates are also of 2009.
Fine.
Your Lordship, they are also barred by limitation.
My lord, the judgments that my learned friend has referred to, they're also
First,
everywhere.
come to the facts. Why these conveyance deeds are not signed?
My lord, my lord, this is what I just noticed, my lord. My lord, these were executed as to my knowledge and information.
Doesn't show from the record it's executed. How can you say it's executed? Where are the executed copies?
These are
not binding
draft-
agreements. If
no,
they're
these
not
are the draft copies, my lord. My lord, but as per
Madam,
my
you have to
instruction,
bring,
those
you have to
deeds
bring
were
in the executed copies on record. For this court to hold that these conveyance deeds have been executed, you have to bring the executed copies on record.
Yes, my lord.
Where are
I
those?
should have brought the executed copies, my lord.
You have to bring them on record.
My lord, my instructions are that these deeds were
Your
executed.
instructions doesn't help me.
Yes, my lord.
For this court to make an observation that the contracts have been executed between the parties, they have to be signed. Where are the signed contracts?
Lord, if I may pray for one accommodation so that I
can
can,
dismiss it on this ground itself.
my lord, and
I go on facts. We don't go beyond the pleading.
my lord, on the first argument that he has referred
Doesn't
to,
matter, madam. He can raise this point at any stage. And this for me to see. These contracts are not executed.
indeed,
I'll give a finding. I'll dismiss it on this very ground that the petitioner has filed this application under 11.6 for execution of contracts which are not signed. Simple.
my lord, kindly gives me one accommodation. I shall come up with the executed deeds, my lord. My lord, if the deeds are not executed, I shall bow down to
Come
your
back with the
lordship.
instruction whether they are executed or not.
Yes, my
Then
lord.
we'll give you time
And
to
with
file
the
your
deed numbers proper.
supplementary affidavit.
I'm grateful, your lordship.
So why didn't you point it out on day one? Unnecessarily you wasted
My lord, the point
first
has
day of
not yet been taken in the opposition.
Doesn't matter, madam.
My lord,
You have to stand on your own foot.
my lord,
If your grounds are not clear, how can you go forward? You forget about what he's pointing out.
my lord, I shall come back with proper instructions.
Learned counsel for the petitioner. Or we'll keep it next week.
Yes, ma'am.
Shall we dismiss it or छोड़ दो next week कर दो सीधे. हाँ? हाँ, just write down affidavit of
Reply.
what have you filed today?
My lord, the affidavit in reply.
Affidavit in reply filed by the petitioner is taken on record. List on. Next week?
Yes.
Give next week.
Grateful, your lordship.
Take the date for next week. What is the date? 29th.
Plus 16.
I appear for the petitioner. It is an application for appointment of arbitrator under section 11. Malada, after the tender process work for construction.
I'll just come back. You're disputing it?
Lordship?
Are you disputing?
Yes, Your Lordship.
This is an application under section 11 for appointment of arbitrator. My lord, construction of 7 station buildings was, my lord, awarded to me by issuing work order. That work order was issued on, my lord, 15/7/2020. Immediately thereafter, on 16/7/2020, I started the work. While, my lord, execution of the work was in process, my lord, they suspended the work, stating that to minimize the expenses. If your lordship kindly takes, my lord, the order of suspension, that is at page 49, annexure F to the petition. 49. May I place it, my lord? As desired by the competent authority, in order to minimize further expenditure to the extent feasible, the above ongoing work should be frozen till further order. My lord, thereafter, my lord, that order was withdrawn and I was allowed to continue the work. After, my lord, I executed and completed satisfactorily 5 station buildings. My lord, the work was closed. My lord, contract was closed. Contract was closed. My lord, then, my lord, completion certificate was also issued, which is, my lord, at page 53, annexure H to my application. 53. Completion certificate against the work, so and so, so and so. Name of the work, number 1. Name of 2. Original value was 4,28,03,041. Now the final contract value is 5,47,30,534 in respect of 5 station building out of 7. My lord, this was made possible by the supplementary agreement because the contract value is less. By supplementary agreement, this was made possible, which is, my lord, indicated in their affidavit in opposition, page 13. If your lordship kindly takes page 13 of their affidavit in opposition about the supplementary agreement. My lord, the Senior Divisional Engineer Headquarters, Kharagpur, sends this letter to the Senior Divisional Manager, Kharagpur. My lord, enclosed here, the supplementary agreement and sanction copy of the competent authority. My lord, this supplementary agreement is possible under clause 41 of the GC's General Conditions of Contract. 41. Say that, my lord, diminution, reduction in value, reduction in quantity, reduction in, my lord, or excess amount, quantity of work will be done only by instrument, that is supplementary agreement. Now this supplementary agreement is, my lord, part and parcel of the, my lord, the principal agreement. Therefore, the value of the contract comes to 5 crores as given, indicated in the completion certificate, 5,47,30,534. My lord, after this, because of the, my lord, there was prolongation of the work due to their own fault and laches, I made a request several times for compensating me because in the meantime there was price escalation. I made several requests. Those are at page, my lord, 52, 53, and, my lord, finally, my lord, 50, I made request for compensation, which is at page 51, price escalation, compensate. Then 52 also, my lord, I made request for compensation. Then this closure, 53 is the, my lord, completion certificate. Then, my lord, by my letter dated 5/1/2026, which is at page 57 of my petition, my lord, I submitted my claims. that those should be settled. Now, my lord, I have enclosed the schedule of claims, starts from page 59. Page 59. My lord, after receipt of these claims, my lord, I was called by the authority, respondent authority, to be present in a conciliation meeting.
Yes.
Which is at page 60. Page 60. At page 61, the meeting was held on 12th February 2026. Conciliation meeting was held on 2026. In that meeting, from the side of the respondent, it was stated that no claim certificate has been submitted by the contractor on 2/1/2025. Therefore, as per the agreement special note 3, price variation clause is not applicable. Contract was duly signed by the agency and railway authority. So further claim of PBC does not comes in this agreement. So their stand is that because I have signed the no claim certificate while paying the final bill in respect of the 5 station buildings, therefore, my lord, I am not entitled to any further claim. No claim can arise. So after these, my lord, I invoked arbitration by my lawyer's notice, which is at page 62. Which is at page 62.
63. 63.
Next page, after 61, I have sent this notice, my lord. 60. So, my lord, after these, I have stated that as per clause, arbitration clause, I have also annexed the arbitration clause contained in the general conditions of contract, which is it starts from page 43 of my petition. Arbitration clause is there in the general conditions of contract. I have annexed, my lord, relevant pages of it starts from page 43. Starts from page 43. My lord, then next page, 44 is the clause 63, matters finally determined by the railway. Then 64(1) is the demand for arbitration procedure. Then if the claim value is less than 10 lakhs, then it is one situation how the appointment of arbitrator will be made. And if it is more than 10 lakhs, then 64(3)(a) Roman 3 III. Panel of 3 arbitrators will be appointed by the general manager. Now at section 12(5) as amended, my lord.
Yes.
If one or more arbitrators appointed as above refuses to Roman 2, sorry, I beg to be excused, my lord. Roman 2, 64(3)(a)(2). Since my claims are more than 2 crores, therefore I am covered by 64(3)(a)(2) at page 46. My lord, in my invocation letter, I have stated that the general manager, being the appointing authority to appoint arbitrator, he cannot act as such because of section 12(5). Because of section 12(5). Then, my lord, I have stated in my invocation letter that I will take steps for appointment of arbitrator. Thereafter, I am before your lordships, I am approaching to your lordships. Now, my lord, what about the no claim certificate? I have signed. Measurement book, etc. All things I have signed the no claim certificate. My lord, on that point, on an earlier occasion, my lord, in section 34, your lordships, after hearing me, was pleased to deliver a judgment. Following, my lord, several judgments of the Honorable Supreme Court, that no claim certificate will not debar the contractor or the agent to apply for appointment of arbitrator. My lord, I am handing up before your lordships. Yes, yes. It is your lordship's judgment.
Yes, I remember that. Yes.
So, my lord, after considering the Honorable Supreme Court judgments and also your lordship's some other judgments, Joyce Engineering Works and Ambika Construction, then, my lord, your lordship was pleased to hold that the (35) viewed thus, page 11, 35. The impugned award suffers from patent illegality appearing on the face of the record inasmuch as it reflects a wholesome non-adjudication of the disputes referred, mechanical reliance on a no-claim certificate, and a failure to render reasoned decision as mandated by law. So, my lord, if on the no-claim certificate only they refuses our claims, it may not be, my lord, it cannot be subject to lordship's what, my lord, be pleased to hold that after the no-claim certificate, my lord, I have issued a notice to them that the no-claim certificate was issued without prejudice because at that time I was under acute financial crisis. I had to sign it. Therefore, it was without prejudice. That notice I have also annexed in my affidavit in reply. So, my lord, only on the ground that no-claim certificate was signed, my claim or request for arbitration cannot be, my lord, turned down. This is my submission.
Yes, Mr. Ashwin.
Lordship, as the petitioners already substantiated before your lordship, that he had signed a no-claim certificate, but this was done without any demur or protest. Now, upon such unconditional acceptance and issuance of the completion certificate, lordship kindly takes the completion certificate. This is at page 53 of the petition, your lordship, the section 11. Contrary to what he claims, your lordship, completion certificate, lordship has page 53.
In our petition, page 53.
Yes.
Completion certificate against the work construction of station building of 7 stations. Now, he says this was not all the work that was done, but I mean, the documents say otherwise, because the completion certificate against work construction of station building 7 stations at Raghunath Bari, Rajgora, Keshavpur, Mahishadal, Barda, Basiullastu Hata, and Durgachak under the jurisdiction of so-and-so agreement number so-and-so dated 28/8/2020, your lordship. Now, if your lordship takes in this completion certificate, serial number 9, whether work has been completed in full respect or not. Work has been completed, final bill is passed. Remarks, your lordship, serial number 11, work has been completed satisfactorily. Now, your lordship, I wish to show R1 from my affidavit in opposition. Annexure R1, your lordship, page 11 of my affidavit in opposition.
Yes.
Completion certificate executed by the contractor under clause number 48(1) of GCC for the work, again, your lordship, construction of 7 stations. So the scope of work was for construction of 7 stations. These 7 stations have been completed. Certified that all the works under the aforesaid contract agreement have been executed, are completed satisfactorily according to the terms of the contract, specification and drawing. Now, your lordship, the last line, guarantee period, maintenance period will commence from 29/6/24. That is the certified date of completion of work. The final bills have been submitted on 26th of July 2024, passed on 25th of October 2024. Now, your lordship, kindly sees page 56 of the petition. Annexure J, your lordship. This, your lordship, is after they have written to us saying that they have an objection. As an afterthought, after they've signed the completion the no claims, they wrote to us. So we replied to them, Your Lordship. We said, letter under reference, the said contract was awarded to you for construction of station building 7 stations at so-and-so stations with a value of 4.28 crores with a stipulation to complete the work within 7/10/21 under reference. But you have completed the said work on 28/6/24 after passing of 50 months. Now, be that as that may, as per agreement, special note 3, price variation clause is not applicable to this contract, duly signed by agency and railway authority. During the execution of work, the agreement value enhancement from 4.28 to 5.61 on mutual consent at the same rates, terms and conditions of the principal agreement dated so-and-so. Hence, the question of compensation does not arise. Now, final bill dated 25/10/2024. Moreover, the contractor has also submitted a no-claim certificate. As per the contractor request, PG has been released on 8/11/2024, and also completion certificate of the above agreement given to the contractor dated 22/11/2024. Security deposit released on 27/1/2025. Now, why I showed this to your lordship first is because of the dates. Now, 27/1/25, I released the security deposit as well. Now, your lordship, in his affidavit of in reply, page number 8, if your lordship takes, annexure N.
Yes.
The date of the letter, your lordship, is 1st of September 2025. And I had released the security deposit on 27th of January of that year itself. And the no claim certificate, your lordship, was issued on 29th of June of 2024, the previous year. Now, your lordship, if your lordship comes to page 8 of his affidavit in reply.
Yes.
He has written to me regarding this. This is an afterthought. He signed the no claims. As an afterthought, if your lordship takes page 9, he says, third paragraph, your lordship, in such circumstances, coupled with the threat and pressure from your end, either to accept the said final bill amount, else it will be presumed that we have no claim for such final bill amount. As such consequential non-refund of our security deposit amount, we were compelled and forced to accept the said much lesser amount of final bill and also to sign the no claim certificate, as also the final variation statement, measurement book, etc. Thereafter, we had to wait till refund of the security deposit on 31/1/2025. Now, the dates are also not matching, your lordship, because we say that we have released the security deposit on 27th of January, and he says that the amount was refunded on 31st. Now, your lordship, in all fairness, your lordship, voluntary acceptance of final payment and signing the no dues, your lordship, it negates the possibility of an arbitrable dispute unless exceptional evidence suggests otherwise, your lordship. As no dues survive, your lordship, there is no dispute to be arbitrated upon. Given that the claim itself is extinguished, no dispute survives, and without the existence of a dispute, there would be nothing to arbitrate. I have 2 judgments, your lordship, to substantiate my argument. One is the erstwhile Chief Justice of this court, your lordship, this is a 2022 SCC online. Copy, give that copy.
2020.
Lordship, in this, facts are more or less similar, your lordship. They had also signed a no claim certificate. If your lordship kindly takes paragraph 7. Lordship has it? It is also not in dispute that thereafter final payment was made to the applicant on 5/3/2019, which was duly accepted by him. There is no material placed on record by the applicant to show that the final bill was accepted under protest. Similar facts in my situation as well. Even after submitting the no-claim certificate and accepting the final bill payment on 5/3/2019, the applicant remained silent for about 6 months. In my case, 9 months. When on 2/9/19, it had issued the notice raising the plea that no due certificate was obtained under duress and making a prayer for arbitration. No prima facie material is placed on record indicating that the no claim certificate was obtained from the applicant on dotted line or under any coercion. Now, Your Lordship, if Your Lordship takes paragraph 8, considering the similar issue in the matter of United India Insurance versus Anti-Cart Exports, in a case where 11 weeks after the issuance of the discharge voucher, for the first time, a plea was raised that the discharge voucher was signed under undue influence and coercion, and no prima facie evidence was filed in support thereof. It has been held that claim was settled with accord and satisfaction, leaving no arbitral dispute subsisting under the agreement to be referred to arbitrator for adjudication. In that case, the decision of the High Court to appoint the arbitrator in spite of the signing of the discharge voucher has been set aside by holding that. Now, Your Lordship, I'm not reading this part. 9, Your Lordship, I'm coming to 9. It is also settled that each case in such a plea is raised is required to be decided on its own facts, and that mere allegation that the discharge voucher no claim certificate was obtained by fraud, coercion, or undue influence, it is not sufficient to accept the plea for appointment of arbitrator. But the party seeking appointment of arbitrator is required to produce prima facie evidence to substantiate plea of fraud, coercion, or undue influence. In the present case, no such prima facie evidence has been produced. Now, Your Lordship, I go over to para 11. In view of the above, the legal and factual position, I am of the opinion that after submission of no claim certificate and receipt of full and final payment without any protest and keeping silent, kindly note this, Your Lordship, keeping silent for about 6 months, in the facts of the present case, the applicant is not entitled to dispute the no claim certificate at this stage and invoke the arbitration clause. Hence, the AP is accordingly dismissed. Nothing prevented them, Your Lordship, at that point, when they were signing it also. There are so many instances, my clients tell me, where the other side signs saying we are signing without prejudice. Nothing prevented them. Nothing prevented them from telling us that this is under protest. But they come up with it as an afterthought, after the security deposit is released and all the amounts are released. Now, Your Lordship, I wish to show Your Lordship a Supreme Court judgment.
Citation all.
Yes,
Citation.
they don't.
Copy of
2018 3 SCC 373.
2018 SCC online
3 SCC 373.
317 17. 3 SCC 317.
373.
373.
Lordship kindly takes paragraph 23 of this judgment. Lordship, this says, the learned senior counsel for the appellant contractor, after taking us through the material on record, submitted that the contract has come to an end and obligations therein have been discharged, and there's no point of raising a belated claim in the form of losses incurred during the execution of the contract, that too after submitting the final bills as well as the no due certificate. Now, Your Lordship takes para 24.
24.
The question that arises is whether the discharge in the present case, upon acceptance of compensation and signing of subrogation letter, was not voluntary, and whether the claimant was subjected to compulsion or coercion and as such could validly invoke the jurisdiction under Section 11 of the Act. Now, the law is clear from the following decisions. When we refer to a discharge of contract by an agreement signed by the parties or by execution of a full and final discharge voucher or receipt by one of the parties, we refer to an agreement or discharge voucher which is validly and voluntarily executed. If the party which has executed the discharge agreement or discharge voucher alleges that the execution of such discharge agreement or voucher was on account of fraud, coercion, undue influence practiced by the other party and is able to establish the same, then obviously the discharge of the contract by such agreement voucher is rendered void and cannot be acted upon. And consequently, any dispute would be arbitrable. Now, Your Lordship, he has not been able to establish the same. Next, Your Lordship kindly takes paragraph 25.
25.
When we refer to discharge of a contract by an agreement signed by both the parties or by execution of a full and final discharge voucher or receipt by one of the parties, we refer to an agreement or discharge which is validly and voluntarily executed. If the party which has executed the discharge alleges that the execution of such discharge was on account of fraud, coercion, undue influence practiced by the other party and is able to establish the same, then obviously the discharge of the contract by such agreement is rendered void and cannot be acted. Consequently, any dispute raised by such party would be arbitrable. But in the case the party is not able to establish such a claim or appears to be lacking in credibility, then it is not open to the courts to refer the dispute to arbitration at all. Now, Your Lordship kindly takes 26 and then with 30, I'll conclude, Your Lordship. So 26, Your Lordship, I want to read the set out part. From the set out part, I want to read 51, which is towards the end of the page. The Chief Justice, his designate, exercising jurisdiction under Section 11, will consider whether there was really accord and satisfaction or discharge of contract by performance. If the answer is in the affirmative, he will refuse to refer the dispute to arbitration. On the other hand, if the Chief Justice, his designate, comes to the conclusion that the full and final settlement or discharge was the result of any fraud, coercion, undue influence, he will have to hold that there was no discharge of the contract and consequently refer the dispute to arbitration. Alternatively, where the Chief Justice, his designate, is satisfied prima facie that the discharge voucher was not issued voluntarily and claimant was under some compulsion or coercion, and that matter deserved detailed consideration, he may, instead of deciding the issue himself, refer the matter to the arbitral tribunal with a specific direction that the said question should be decided in the first instance. Now, Your Lordship, I want to come to paragraph 30. From the materials on record, we find that the contractee company had issued the no-claim certificate on 21/9/2012. It had received the full amount of the final bill, being 20.34 crores, on 10th October 2012, and after 12 days. Thereafter, on 24th, the contractee company withdrew the letter issuing the no-claim, no dues. Apart from it, we also find the final bill has been mutually signed by both the parties to the contract, accepting the quantum of work done, conducting final measurements, arriving at final value of work, payments made, and final payment that was required to be made. The contractee company accepted the final payment in full and final satisfaction of all its claims. We are of the considered opinion that in the present facts and circumstances, the raising of the final bill and mutual agreement of the parties in that regard, all claims, rights, and obligations of the parties merge with the final bill, and nothing further remains to be done. Further, the appellant contractor issued the completion certificate, pursuant to which the appellant contractor has been discharged of all liabilities. With regard to the issues of no due certificate had been given under duress and coercion, we are of the opinion that there is nothing on record to prove that the said certificate had been given under duress or coercion, and as the certificate itself provided a clearance of no dues, the contractee could not now turn around and say that any further payment was still due on account of losses incurred, exactly what my learned friend had said, during the execution of the contract. The story about duress was an afterthought in the background. that the losses incurred during the execution of the contract were not visualized earlier by the contractee. As to financial duress or coercion, nothing of this kind is established prima facie. Mere allegation that no claim certificates have been obtained under financial duress and coercion without there being anything more to suggest that does not lead to an arbitrable dispute. The conduct of the contractee clearly shows that no claim certificate was given by it voluntarily. The contractee accepted the amount voluntarily and the contract was discharged voluntarily. Lordship, I rest my case.
I'll give reply. Only thing is
Reply after lunch.
after lunch. Judgment copy দেবেন আমাকে?
Lordship, I seek to distinguish the judgment that he has cited. Right.
You can do it, then continue after lunch and then.
Right.
Yes.
With respect to the note that is Maris Karatna and 2011 and 2000, both these judgments that I have cited in terms of facts and in terms of the observation of the Supreme Court. Facts of my case. Wherein there was the petitioner who did not record a lot of letters
For the judge to be able to adjudicate that there existed a prima facie case, Your Lordship. However, in my case, Your Lordship, no evidence of that sort exists. So that is what I want to submit, Your Lordship, with respect to this.
Yes. My lord. My lord, my learned friend has taken 2 points. First one, no claim certificate. Once you have issued, is signed, you have no case. And then there is no dispute and PVC clause. Now, I will kindly see that no claim certificate was issued or signed by me on 21st January 2025, which will be evident from page 11 of their affidavit in opposition.
You have also filed that?
Yes, it is in their affidavit in opposition. It is in their affidavit in opposition, page 11, certificate part, just above certified that, certificate that I have no further claims so and so. Signature, Mother India Construction, contractor, 21/1/2025. But before that, I went on making my claims and request for compensation and towards price escalation. Not that, as my learned friend has stated and submitted, afterthought, much has been submitted as afterthought. Not that, not correct. Why I am telling you, Lordship, after your Lordship may kindly turn to again page number 50 of my application. Page 50 of my application. Much prior to these certificates was signed. 29/11/2021. I have, my lord, in that letter asked for compensation and for price escalation. If I may place before Lordship from next page 51. Next page 51. I have already paid the total charges of the said bank guarantee amount, but the job has postponed since November 2020. Due to postponement of the job, I have to bear huge financial loss, which I cannot bear, such as machineries, materials, staff salaries. Being MSME agency, this kind of loss is unbearable for me. So I am requesting you to look after this horrifying situation and compensate me for my losses, and also release my third bill as quickly as possible. Since the starting of the job, the market price of the materials has increased unimaginably and unrestrained. Notably, the price of steel, TMT bars, and cement has increased approximately 100% and 20% respectively. Also, the market value of all other materials such as like sand, stone aggregate, bricks, aluminum, sanitary items, tiles, granite, etc. are also increasing simultaneously. In this situation, I am requesting you to kindly give me assurance for price escalation as per market value. Otherwise, it will be impossible for me to restart the job after very long period time due to postponement of the job. So that thereafter other notices in the similar line. So therefore, I am placing this before your Lordship to establish that it is, my claims are not afterthought. The situation was that the completion period was prolonged for the reason.
That's not the argument she's trying to make, sir. If you have anything to show after the period when you have issued a no claim certificate, anything prior to that, whatever you have said, they have completed it. They are saying that after the no claim certificate, you have not raised any further claims that you have signed it with coercion, duress, or any fraud. Nothing of that sort.
I have, yes. My lord, just for a minute, my lord, I have thereafter also similar line of claims and requests I have made.
Which page?
Then, my lord, after this, I made my application or request to them, my lord, that is at page 54. I have stated, not in exact language, fraud by fraud and so, not in exact language. But what happens is that before signing the no claim certificate and final measurement and variation certificate, the contractors are asked to come to the office of the concerned officer to sign the final variation statement, measurement book, and the final bill and the no claim certificate. Otherwise, it will be presumed that the contractor has no claim further. He has no claim for the final bill. This is the practice followed. Those are the letters given to the contractor just before payment of the final bill. Just before payment of the final bill. These are the undue pressure, that in that way, the undue pressure are being placed on the contractor, that either you accept the final bill, measurement and final variation statement, or you have no claim, it will be presumed. This is the practice followed. Now, my lord, I have not annexed that letter. My lord, if your lordship kindly allow me to, my lord, at this stage, I am also a little bit hesitant to ask your lordship to allow me to supplementary affidavit to bring on record that certificate, that letter, that I have been asked to sign the measurement and final variation statement, which they could have placed before your lordship by the affidavit in opposition, which they have not done. This is the procedure followed as per the contractual general conditions for contract provision. This is the procedure followed. Now, my lord, hereafter, my lord, when I placed my claim by my claim letter at page 57, there also I have stated that the claim certificate by our letter was recorded. Our protest that we signed the no claim certificate under protest without prejudice. It has been done. We have annexed in our affidavit in reply under protest. But there is no document, as my learned friend argued and made submission, that there is no specific document to show that it is that these claims, no claim certificate signing was under protest, under fraud exercised by them on us. No such document. But at the same time, kindly consider, my lord, that in RL Calcutta company case, my lord, which your lordships considered, and my lord passed the judgment which I have placed before lordship. In paragraph 13 of that judgment, if your lordship kindly consider it afresh, this judgment was considered in that judgment. Paragraph 13 of that judgment, 10-11, citation to 2011 volume 2 SCC page 400. What is citation? Paragraph 13, my lord, your lordship will kindly, my lord, excuse me because some portions are marked. My lord, kindly excuse me, my lord. Kindly. Paragraph 13. From the above conclusion of this court, the following principle emerges. Merely because the contractor has issued no due certificate, if there is an acceptable claim, the court cannot reject the same on the ground of issuance of no due certificate or no claim certificate. My lord, even after the contract was closed, I will place subsequent paragraphs. Let me first place this. Inasmuch as it is common that unless a discharge certificate is given in advance by the contractor, payment of bills are generally delayed, as I placed before worship. Hence, such a clause in the contract would not be an absolute bar to a contractor raising claims which are genuine at a later date, even after submission of such no claim certificate. My lord, kindly consider this aspect that if by your lordship's judgment and order the disputes are referred to arbitration, then we will be able to establish that the claims are genuine or may not be genuine, but that is to be considered by the learned arbitrator or arbitrators. But from the fact situation, I have stated that even before the closure of the contract, I have been making request due to prolongation of the completion time beyond completion initially agreed schedule time. I have suffered loss. This is prima facie a case that I have suffered loss. Prima facie a case. Your lordship will consider that whether your lordship will be satisfied prima facie that the claims are genuine or not. Claims are genuine or not. My lord, from the Roman paragraph Roman II, Roman 2 under paragraph 13 of that judgment, RL Calcutta case, it is very clear that the discharge certificate is given in advance by the contractor. Payment of bills are generally delayed. Hence, such clause in the contract would not be absolute bar. Even I have not made any specific statement of fraud or any pressure exercised on me for obtaining the final bill. My lord, this is, my lord, in RL Calcutta's case. And at the same time, my lord, in Joyesh Engineering case also similarly it was held.
Just give me the paragraph number. It's okay.
Yes, my lord. I am giving one. Paragraph. It is paragraph, my lord. Only one paragraph. Page 2, 179, running page 179 of the judgment. This is also, my lord, marked, underlined. My lord, when this direction was cited before the High Court, the same was distinguished by stating that it is decision on its own facts and has no application of this. We find that this view does not appear to be correct. Whether any amount is due and to be paid and how far the claim made by the appellant is tenable are matters to be considered by the arbitrator. In fact, whether the contract has been fully worked out and whether the payments have been made in full and final settlement are questions to be considered by the arbitrator when there is a dispute regarding the same. But I have to prima facie satisfy your lordship that my claims are genuine in the facts and circumstances of the case. Prima facie, I have to satisfy your lordship. The prima facie satisfaction, my lord, comes from the prolongation and duration for the reason attributable to them, my lord. Attributable to them. My lord, kindly consider under section 16(1)(a) of the Arbitration Act 1996. Wait a minute.
Mr. Sen, this is a rejoinder. You're going on arguing unnecessarily. You just have to counter the point she has argued. Why are you making another statement? It's enough. You have done your job.
Only thing, my lord, the arbitration clause is
already have done your job.
Independent agreement.
Enough. See.
My lord, so my prayer is that maybe disputes may be, my lord.
We'll see that.
Deeply obliged.
Please happen.
May it please, my lord. And for the petitioner, this is my section 11 application. On the last occasion, my learned friend had to file a supplementary affidavit showing the partnership deed.
You've given a copy?
Lordship, I have a copy. Lordship, it is the same partnership deed that we are referring. We had referred the draft copy. He is referring the final copy. It's the executed one. And in this copy, the arbitration agreement is appearing at clause number 31. And the date remains the same.
Yes.
Lord, first of all, my lord, there exists some material irregularity in their original petition, my lord. My lord, in reply to their section 21 notice, my lord, I have categorically stated that, my lord, arbitration clause, my lord, which they referred is not correct. Now, my lord, in the petition, they have wrongly referred arbitration clause. And next point is, my lord, I have taken in my affidavit of opposition that, my lord, Lordship kindly see, my lord, paragraph 18 of my affidavit in opposition. Paragraph 18. Reply I have annexed in my affidavit in opposition acts annexure R1. And my lord, paragraph 18, my lord, I have stated, my lord, page 7 to my affidavit in opposition, paragraph 18, from 4th line. The petitioners derive their claim solely on the basis that the petitioner number 1 is the widow and petitioner number 2 is the son, and both are legal heirs of late Gautam Shah, who was formerly a partner of the firm. Mere status as a legal heir of a deceased partner does not confer upon the petitioners the status of a partner, nor does it create privity of contract between the petitioners and the respondents. The arbitration agreement is a consensual contract binding only upon parties thereto and persons claiming through or under them in circumstances recognized by law. The petitioners have failed to establish that they are either a party to the arbitration agreement, a partner of the firm, a person validly inducted into the partnership business, or otherwise entitled to invoke the arbitration clause. Now, my lord, they are the legal heirs, my lord. They are, my lord, and my lord, in partnership deed, my lord, on the death of a partner, my lord, it was clearly mentioned, my lord, what will be the consequences, my lord. My lord, if they have any claim, my lord,
Legal heirs.
For arbitration, my lord.
Legal heirs.
Yes, my lord.
Which section
Section
is it?
40, my lord. Section 40.
Yes.
Section 40, my lord.
You've seen
I have
it?
seen.
Yes. So it's applicable. Whether they are signatory, not signatory, it's applicable.
Lordship, and interestingly, might I as well add, in this partnership agreement that they have given, in clause number 17, it has been incorporated the death, insolvency, or lunacy of any partner, the proportionate share of the said partner shall be transferred to their family member.
Yes, my lord, that is, my lord, in the matter of.
This has been also.
In terms of section 40, the legal heirs are part of the
Yes, my
contract.
lord. That, but my lord,
yes,
my lord, Lordship kindly, my lord, consider, my lord, paragraph 18, my lord.
I've considered paragraph 18.
My lord, mere paragraph 18 of my affidavit in opposition.
That's what I'm saying. It's contrary to law. Your paragraph 18. That's not the legal settled position, sir.
And now, my lord, my submission is that, my lord, they have annexed the partnership deed, my lord, which was not signed. And my lord, and there exists, my lord, in a material irregularity
Why
in the
have
partnership
you
deed.
annexed a partnership deed which was not signed? And
That was a draft agreement.
how can you put a draft agreement for
Lordship, the reason
purposes
is
of this
that
petition?
the reason is when my husband died,
Yes.
when the husband of the petitioner died,
Whatsoever it is,
the
on this
email,
basis,
Lordship.
this is absolutely his right to point it out
Lordship.
that this cannot survive on the basis of a draft agreement which you have filed.
Lordship, but the
If the clauses are different, they are not matching.
Lordship, these there are no different clauses.
There are different clauses.
Arbitration clause is
Arbitration clause is which clause in this draft agreement?
In this draft agreement is in 25.
And it is in the final it's 31.
30.
I'll dismiss on this ground.
Lordship, may I only
I'll
get a
dismiss on this very ground that you have filed this petition based on the draft agreement, which is contrary to the final
date of
executed
the
agreement.
remains
This
same.
petition doesn't matter.
Lordship, I
Rest of
understand, but
material particulars, this petition is dismissed.
Lordship, may I have a leave to withdraw this? May I have a leave to withdraw and file afresh? Because
Learned Counsel for Petition seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
I'll dismiss on this very ground.
Lordship, now I have the agreement. The only reason because I had no option other than this agreement, because while my husband died, I had no other documents. They refused. I even asked various times to them to give me the original.
Even later today.
Yes, various letters. That is the reason now that I have the agreement. I apologize. Lordship.
Can you issue a fresh 21 also?
I'm great.
On your 21 also, this can be dismissed.
I will give a fresh 21 and thereafter file. I'm great.
This is my Section 11 application. Last occasion, Lordship asked me whether there's a possibility of mediation or not. But my client is not willing for mediation. There was an agreement. Yes, my lord.
Tell me.
Yes, ma'am. There's an agreement because I need to pay some money. There's a development agreement between the petitioner and the respondent. I need to pay some money for enhance of the development agreement. I paid. There's a consideration, my lord, for any development. I will get 50% of the share or whatever the X amount of ratio. I found that their flats has been, my lord, erected and I have not got my share. I have sent a legal notice, not replied. Section 21 notice, my lord. Thereafter, my lord, I am here before your lordship. There's an arbitration clause, my lord, also. I've only claimed for the principal amount, not even the profit, my lord. Page number 19 is the arbitration clause of the agreement.
Where's the agreement? Starts from page?
Page number 16.
Agreement starts from 13.
Yes, no, 13, sorry. 19 is the arbitration clause. Section 21 is starting for page number 51. '54 is the last paragraph. Section 21.
Keep me in dark and being another this time. That is why that is
My lord, only the two submissions, my lord, as earlier mentioned that as per clause 7, we adjusted at the end of the project. My submission was all earlier occasion and today also the project not yet completed. And on 24th, already he, by a mail dated, he withdrawn. He said, I have decided to cancel the agreement and which I have decided to cancel the agreement. It is on mail I have on 15th April 2024 and thereafter he not pay a single farthing. So I have to borrow the money from the other persons and all these.
They can raise this before the arbitrator. Whatever they can.
I'm just since he is submitting, I'm to
it itself has been revised.
Let it go before the arbitrator.
Yes, my lord.
You don't have issue.
No, because he not agree with for the mediation for the simple calculation since he's not agree what can be.
Take note. There's an application filed under section 11(6) of the Arbitration Conciliation Act seeking appointment of a. Is it a sole arbitrator or
Sole arbitrator. My lord, we,
Sole arbitrator.
as mentioned, Mr. Shaptanshu was the senior advocate.
no? No. What is the clause? Clause.
Any clauses, my lord?
Page 19.
Page 19.
Page 19.
Simple. The single arbitrary clause considered.
Yeah.
Decided by both parties.
So this is 3 arbitrators, right?
Yes, my lord. 3 arbitrator.
To an arbitral tribunal, appointment of an arbitral tribunal for adjudication of the disputes that have arisen between the parties under an agreement dated 1/12/2020. The petitioner had entered into an agreement dated 1/12/2020 with the respondent in relation to the development of a property situated at 56/1 Hazra Road, PS Garyahat, Calcutta 70019, Ward number 86, Borough 8. Full stop. The respondent being a partnership firm and its partner had entered into a registered development agreement with the owners of the property. Full stop. Under the agreement dated 1/12/2020, the parties agreed to jointly undertake the development of the property by constructing a 4-storied residential building to a residential building. Full stop. The petitioner agreed to bear the entire investment towards sanction of the building plan, shifting charges, construction cost, and all other incidental expenses. The agreement further provided that the net profit arising from the project would be shared between the petitioner and the respondent number 1 in the ratio of 65/35 up to profit of 50 lakhs, and thereafter in the ratio of 70/30 after adjustment of the cost and respective tax liabilities.
Well, subsequently by email dated 15th April 2024, as I mentioned, it has been revised on 50%. Well, this is the mail this
Where is the mail?
petitioner sent to me, to my client, at the time of withdrawal of the agreement.
Why didn't you annex it?
No, I don't, we don't have. No,
Your client doesn't give you information.
Today, first time we are getting this information.
Letter file or affidavit then in that case.
They can make this argument through the arbitrator, that will do.
It has to be on record, sir.
Yes,
Either you
it has
put it or she puts it.
Yes.
Why didn't you put it?
No, I didn't have any information.
So why your client is not giving you correct information when you are coming to the court?
Have to ask.
Either you file a supplementary affidavit.
My lord.
Strike it down. This is an application filed under 11(6) of the Arbitration Conciliation Act seeking appointment of an arbitral tribunal for adjudication of the dispute which have arisen in terms of the contract entered into between the parties dated 1/12/2020. Full stop. Learned counsel for the respondent states that the petition is bereft of material particulars and that the terms of the agreement had been modified by the petitioner by an email dated
15th April 2024.
15th April 2024, which is not on record. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time, 3 weeks time,
3 weeks.
4 weeks, 4 weeks time to file affidavit in opposition, reply after 2 weeks, list after 8 weeks.
Okay. 4 weeks.
4 weeks to 18, sir.
Agreement. 19.
Lordship, I appear for the petitioner, Your Lordship.
I appear for the respondent, Your Lordship.
Yes. This is Section 11 application, Your Lordship. Lordship, may kindly please
What agreement?
page 34, Your Lordship. We had filed a civil suit. They had filed a Section 8 application.
Right. Then
Thereafter, that was allowed. Your Lordship kindly sees the order at page 30.
this is arising out of what? Lease deed.
A lease deed, Your Lordship.
What are the terms of the lease deed?
The terms of the lease deed
Who are
was
you?
that
What are they doing? What service? At least tell
yes,
something.
I'm coming to that, Your Lordship. This is for tower installation.
Tower
installation, Your Lordship, 20 years lease. Lease was entered into in 2020. In 2022, they left. They did not make any payment, because of which we had filed a civil suit. They filed a Section 8 application that was allowed, that this matter is regards to arbitration. We made a notice, Your Lordship. They have been unresponsive to the notice. That is why
They had taken your property for erection of a tower.
erection of a tower. They erected, all of a sudden, one fine morning we see they are not there anymore. They have not made any payment also. So we filed a civil suit. They filed a Section 8 application. That was allowed. That order is at page 34, Your Lordship. Page 34, Your Lordship. Specific part, Your Lordship, is at page 39. The operative part of the order. And
Yes.
And Your Lordship, kindly
You
just
agree to the arbitration? No.
Lordship, they have not given any 21 notice.
we have given a notice, Your Lordship. It is at page 81.
Your Lordship comes to page 82 once.
Let's see.
Page 82, Your Lordship. They have given us 7 days. The statute timeline is 30 days. Their notice is bad.
Your Lordship, just because they have stated 7 days, the advocate there, the intent for arbitration is there.
Their section 21 notice is bad, Lordship.
Give a fresh 21 notice.
Your Lordship, kindly sees page 38
Yes.
once. It is their Section 8 application.
That's all right. They are not saying anything, but you have to give a.
Your Lordship, this is a hyper technicality. 7 days they have written. We have shown our intent for going for arbitration. We have shown our intention that we want to go for arbitration.
Judgments which says 21 notice. The exact time period has to be given.
Lordship, I'm not carrying right now, but the statute mandates 30 days.
That statute mandates, but the notice
30 days
specifies also 30 days. It will be in terms with 30 days only. 30 days has expired, Your Lordship, also.
It's 7
From-
days. And
From the date of this
All
notice,
right,
30
take
days
the-
also expired.
I'll hold the 21 to be bad.
Your Lordship,
That's
he'll
okay.
unnecessarily suffer for 11 lakhs.
That's
Your
all right,
Lordship.
sir. What can I do?
This is a
If your
technique-
lawyer doesn't know the law,
But then the litigant shouldn't suffer for the mistakes of the lawyer, Your Lordship. The dated is 17/7/2025, Your Lordship. 30 days has
litigant
long
should
since.
not suffer for the fault of a lawyer. So
Or
the
this
lawyer
is a
can do
technicality,
anything.
Your Lordship.
It's a
This is-
technicality. What does the statute say? Read the section.
Your Lordship, the statute.
Read the section.
Lordship, the
Where's the act? Why don't you carry the act?
Your Lordship.
Not today.
Your Lordship.
Not today. Get your own book.
It is.
Come with the law and
I
don't
understand.
put your hand in the pocket.
No, Your Lordship.
You're not going to take out your phone and read the sections.
I understand.
Get
Your
the
Lordship.
book.
Yes, Your Lordship. If I may, I understand.
Not today. Do you get that? And I'm the most lenient with juniors.
I
So
understand.
don't irk me.
No, Your Lordship, I'm sorry.
Do you get it?
I
Come with the statute. Come prepared with the book.
Definitely, Your Lordship.
I'll dismiss it. Give it.
No, Your Lordship, I'm
No,
Your
I'm
Lordship,
generally not like this, but I should
I did
do
not
it.
say anything, Your Lordship.
I
I'm
should
asking
do
for
it.
pardon, Your Lordship.
Take down.
Your
The
Lordship,
petitioner.
Your Lordship, kindly gives me some time then.
Learn to address the court first of all.
I
Learn to address the court.
yes, Your Lordship.
Come prepared
Yes, Your Lordship.
with
I'll
the
come-
bare act.
I'll come with the bare act, Your Lordship.
Don't put hand in your pocket. Try to take out your phone.
I did not understand that this question will be taken up, Your Lordship. That is why.
When you come to the court,
I
you come with the statute book or not?
Yes, I do come with the
You
statute.
come without the bare act.
No, Your Lordship.
What's your name?
Shayun Chattopadhyay, Your Lordship. I'm seeking pardon, Your Lordship. I understand. I'll bring the bare act next year.
Well, I'm very lenient with the juniors.
I understand, Your Lordship, but it's my fault. I'm seeking apology also, Your Lordship. If kindly allows me,
Seek apology and come back.
I'll come back, Your Lordship. Your Lordship.
Yes. My application. It's affidavit of service not delivered. May I, my lord? If my lord kindly comes to page 15, there's an agreement between the parties.
Who's on the other side?
My lord?
Who's on the other side?
This is appearing for the first time. I've served. The good service is there, my lord.
Yes.
And page 15, the agreement starts. Page 19 is the contents of that agreement, my lord. The contents of the agreement.
Agreement is what? What?
Agreement, it is although it's couched as a purchase agreement, it is manufacturing and delivery agreement. I'll supply raw materials. They'll purchase the raw materials from us, and they'll manufacture goods from those raw materials and deliver them. Now, my lord, my claim is I have delivered to them the raw materials which was proposed to be used in the manufacturing. They have not paid that amount to us. Now, my lord, that is the agreement. My lord will find page 25. My lord will find manufacturing and delivery of goods. That is the rights and liabilities of the parties involved in that agreement. Now, my lord, if my lord kindly comes to page 48, my lord will find the arbitration clause.
Page 48.
Page 48, clause 39. There's an arbitration clause. Now, total due and payable were 36 lakhs odd. Now, my lord, initially there was a termination notice. My lord will find that at page 151 of the application, my lord. There's a termination notice. Subsequently, there's a demand notice or termination notice is at page number 151, which is dated 18th of July 2025. Then thereafter, my lord, when it comes to page 153, which is the demand notice claiming payment of, my lord will find that payment claim at 155 paragraph 6. Thereafter, my lord, section 21 notice, my lord will find at page 164. Paragraph 17, page 168 is me referring the dispute to my proposed arbitrator, which was not replied to, my lord. That is why I am before your lordship. One more thing, I'll point it out to your lordship. If my lord kindly comes to page 170, the track reports with regard to the section 21 notice, the remarks is my lord kindly sees door locked, intimation delivered, unclaimed. But I'll argue that these are all good services, my lord. I am carrying the judgment. These are all good services.
Show me door locked, good service.
Intimation delivered, unclaimed. This is the last.
Yes.
Yes, my lord, this is a judgment of a coordinate bench with regard to presumption of good service.
Unclaimed is returned to sender.
No, my lord, unclaimed is a good service. That is the point.
Unclaimed is good,
Good service, my lord. That is, this is with regard to presumption of service, paragraph 2.
Yes.
May I read, my lord?
Yes, read.
And there's a Supreme Court judgment, my lord, I have just handed over. If my lord kindly see the Supreme Court. देखिए जो होता है आगे दिलाना ठीक है My lord kindly comes to internal Supreme Court judgment, internal page 2, last bottom absolute bottom paragraph, my lord. In the opinion of this court, it is not proper and correct. The word refusal can be interpreted in synonyms to the word unclaimed. As held by the Honorable Supreme Court in above decisions, when a notice is served to the proper address of the addressee, it shall be deemed to have been served unless contrary is proved. Thus, when the notice is returned as unclaimed, it shall be deemed to be served and it is proper service.
Where are you reading?
My lord, Supreme Court judgment, my lord, second page, last paragraph. It starts with, in the opinion of this court.
Yes.
In the opinion of this court, it is not proper and correct. The word refusal can be interpreted in synonyms to the word unclaimed. As held by the Honorable Supreme Court in the above decisions, when a notice is served to the proper address of the addressee, it shall be deemed to have been served, deemed to be served unless contrary is proved. Thus, when a notice is returned as unclaimed, it shall be deemed to be served and it is a proper service.
Take down. It is not service.
My lord?
It is not service. I'll distinguish both the judgments. I'll distinguish both the judgments and I'll dismiss it.
This is with regard to the unclaimed.
Both, sir. Both. Don't worry. Both the Supreme Court as well as this court, I'll distinguish and I'll dismiss your 21.
With regard to the intimation served, my lord, this is all I can do. This is the address which was provided in the agreement. I have served.
Challenge it.
My lord?
Go challenge it.
No, my lord.
Take down.
Then my lord, kindly grants me a time. I'll bring more judgments if necessary, my lord.
Bring more judgments. I'll distinguish both of them. I'll dismiss it. Because the unclaimed, the way you are reading it, is not how I read it. Unclaimed is going back. See,
intimation served is the
your reading of Supreme Court is not correct to the extent that is for the respondent. It has come back as unclaimed. Here, the packet has gone to the sender as unclaimed.
Yes, because the intimation was served, it was unclaimed by.
You want to come back with more judgments, or I'll dismiss it?
I'll have another one, my lord. May I just rely on that? If my lord's not satisfied, I'll
come back next time.
No, my lord, I have another one prepared with me right now. If that is not suffices, my lord, I'll come back next time. Can you kindly cease? Oh.
Yes. Which paragraph?
Paragraph 23, 24, and 25. Here the notice is returned as unclaimed, as not as refused. My lord, got it, my lord? Paragraph 23, internal page 519.
Yes.
Here the notice is returned as unclaimed and not as refused. Will there be any significant difference between the two so far as the presumption of service is concerned? In this connection, a reference to the section 27 of the General Clauses Act will be useful. The section as reads, my lord, I'll not reading the meaning of service by post, where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either of these expressions give or send or any other expression is used.
Sir, factually, please try to.
Yes, my lord, this is with regard to this is
Just a minute.
Yes, yes.
Your own facts I'm talking about.
Yes,
please have 170. Please. Page 170.
170. Yes, my lord, I'm on 170. Yes, ma'am.
Who's the sender here?
I am the sender.
What does it say?
It's returned to the sender because after the intimation was served.
What are the judgments saying?
If it's returned to the sender, the Supreme Court judgment says Thus, when a notice is returned as unclaimed, it's returned to the sender.
Just see that it says the first line.
Yes.
The report, it says served to the respondent unclaimed. And that is
No.
how they are using it as a synonymous to refusal.
Yes,
Not in your case.
returned with the remarks sender. It's returned by the returned to the
Yes, sir.
sender.
Not today. But I know I'll dismiss it
I'll take my chances
on a better day.
I'm grateful, man.
Applet side.
I'm grateful.
Circuit bench पहले.
My lord, I am for the petitioner, Jalpaiguri Circuit Bench.
Yes. Yes, you are appearing.
My lord, I am led by Mr. Shomujit Loskar, appearing on VC, my lord. For the Alice
respondent.
For the respondent contender.
Where is he? Where's the reply? Compliance affidavit.
Affidavit of opposition has been
Yes, my
filed.
lord. My lord, I am appearing on virtual mode, my lord. Kindly permit me to appearing on virtual mode.
Yes,
from,
where is the reply?
I have replied with all the necessary documents, my lord. With the opposition, I have filed, and with all necessary documents, I have filed.
Where is it?
My lord,
Is any where's the reply?
I have filed the opposition, my lord. On
What opposition? You have to file compliance.
yes, I have filed the compliance also.
Where's
with
the compliance
opposition.
affidavit? Give it. Where is the compliance affidavit?
Sir, I have filed in circuit bench, my lord.
Circuit bench has filed, my lord.
You have to hand it over. Why did you give a copy here? Your junior is here. Why you have not get?
Yes, I have a copy with my junior, my lord.
No, this is not the original copy.
It's they have filed it. No?
Yeah, we have filed it, my lord.
Yes, Mr. Burman, you have got a copy.
No, your lordship. My lord,
No, I have
filed it without serving.
No, I have given them by mail.
Mail, I received your lordship. I received the affidavit in opposition. I did not
Yes.
receive the
With
affidavit.
compliance, all these documents are there with attached with the mail.
They filed, your lordship, they filed affidavit in opposition. Your lordship order is directed them to file the affidavit of compliance, but they filed the affidavit in opposition by saying that it is a title dispute. We misguided the court.
No.
Yes, your lordship, it is on the record.
It's an affidavit in opposition.
Yes, my lord. It's opposition, but we have complied with all the documents.
How can you file an affidavit in opposition? When did you pass out from law school? Don't you know? What are the directions passed by this court?
Your lordship, last time it was directed by your lordship that we have to file opposition, affidavit in opposition.
Not opposition.
No, your
God.
Are
you the panel counsel?
No, lordship.
Who's the panel counsel? Mr. Palit, are you on record? The lawyer? Who's the lawyer on record?
Answer.
My lord.
Do you understand law?
Thank you, my lord.
Thank you.
আরে বলছে যে তুমি অপোজিশন ফাইল করতে বলছিল তো তোমাকে সেটাই কি I have filed the affidavit in opposition, my lord.
What are you supposed to file, sir? Affidavit in opposition or compliance affidavit? What are the proceedings? This is a contempt. Do you understand?
Yes, my lord.
Is it a writ petition?
No, no, no.
Then what are you filing?
Zero.
Don't you even know this much? What to file? And if you don't know, at least read the order passed by this court. Who has put you on the panel? Who do you represent?
Pradhan.
Good luck to the Pradhan then. He'll surely go to jail.
My lord, 2 weeks accommodation maybe. I will file it in the next day with the compliance.
File a compliance report
Okay,
in terms
my
of
lord.
the direction passed by this court.
Okay, okay. Next time. I'm sorry for that.
Honored counsel for the respondent, the alleged contender, Mr. Palit, seeks and is granted further time of 2 weeks to comply with the order dated 11/6/2026. List after वो एक डेट कोई रखा हुआ था ना? Six, 7th August. 7th August. 7th August. File it before 7th August.
I will file the affidavit in compliance. Grateful, my lord. Grateful.
हाँ petition. Barbara.
Item number 2, Your Lordship, I am for the petitioner, Your Lordship. This is the first time the order passed by Your Lordship on 16th of March, Your Lordship. We have communicated the order on 18th of March, Your Lordship.
Laid on, the petitioner has preferred the present contempt application alleging willful disobedience on the part of the respondents in failing to comply with the order dated 16 March 2026, passed in WPA 391 of 2026. Full stop. Respondents are directed to file the compliance affidavit within a period of 3 weeks. Affidavit of compliance shall be filed positively on the adjourned date. Let the matter appear on 28th. एक और डेट कोई बीच में निकालो, एक बीच का डेट निकालते हैं फिर। मैं बताती हूँ। नहीं
14th. 14th.
Much obliged, Your Lordship.
This is over, huh?
Ticket number 1.
My lord, I am for the petitioner. My lord, your lordship, kindly see your lordship's order dated 11/6.
They were supposed to file compliance affidavit.
I am not.
No,
I am for the petition.
they were supposed to file, sir, not you.
And not only affidavit of compliance they have filed, but also they did not pay
the
the
government has
pension.
also, the government has also changed, you know it.
No. The same council appeared after the change of the regime. He
Where-
told me that he appeared for the administrator.
Where is he today? Nobody is here.
Well, earlier day, Shamal Kumar Das appeared. Your lordship, can you see 11/6? And this order has been passed on 11/6.
Give a notice to him. He's not here.
No, he has not been given pension for last 4 months. He cannot eat. He has no money to eat. He's absolutely in the starvation. They did not pay gratuity. Even they stopped the pension from March.
Where's the final order?
Well, the final order. Your lordship, kindly come to this page 16 of the contempt petition, of the main of the contempt petition. Yes.
This is not the final order. This is list for you have come against this order.
1 minute. It is actually changed brief. The 23/4, your lordship was pleased to direct them to do certain thing. And for compliance 7/7. From there, they did not.
The
7/7.
writ is still pending.
No, writ petition has been disposed of.
Where?
কি করেছে আগের উকিল? মানে no, the order of 23rd April 2025 is under violation. That is the allegation. একই চিঠি দিয়ে একই চিঠি। No, I'm sorry. This is the 7/5. It was a very good. এখনই ব্রিফটাকে দিয়ে দিন এটা।
You're showing me the wrong order, sir.
Yes, 7/5. I'm sorry, my lord. I'm extremely sorry. That's their statement, paragraph 1.
He was appearing for the municipality.
He was appearing for the municipality. Now he is appearing for the administrator.
The municipality is still there. Is it functioning?
Municipality is not there.
Not there. So
Administrator, I have asked him whether you are appearing for the administrator or not. Boli, yes, I am also now appearing for the administrator. That's why he appeared.
have you made the administrator a party? Have you made the administrator a party?
No. On the last occasion, the administrator has been appointed on.
So, sir, please, can you make the administrator a party if he has been appointed on the last date so that we can pass effective orders?
Very well, as your lordship pleases.
If he is not
because he told me.
Sir, he might have told you. You have
Yes,
to
yes,
leave as a party.
Yes.
How will I pass an order if he is not a party?
Yes. That's right. That just now I have told my learned junior, the administrator should be made a party. Just now. Now I have told.
When you know it, then learned counsel for the petitioner seeks and is granted liberty to implead administrator as a party to the present proceeding since the municipality ceases to exist.
Your lordship, kindly give me 3 days time so that I can.
The administrator has been made the concerned. What do you call? The administrator becomes the
administrator. The SDO become the administrator.
Municipality ceases to exist and the administrator takes up.
Your lordship, kindly indicate the SDO. Administrator of the municipality.
Administrator of the municipality. Seeks and is
administrator of the municipality.
liberty to make administrator as a party respondent to the present proceeding. वो भी जोड़.
And matter will appear.
We can keep it on the 7th of August.
7th of August.
Yes.
But kindly make it earlier because
I can't, sir. I
know your lordship is hard pressed with the original side. I know it. Regularly, I am watching the list.
7th is an early date which I can give you. Otherwise, the dates are much beyond. So we are keeping few matters on the 7th. We'll keep it on the 7th.
Very well. We are making him party.
You make him a party. We'll pass some effective order. Serve him and we'll make him a party. That's why he's not appearing.
Very well.
Yes.
My lord, item number 2, my lord, I am appearing for the petitioner, my lord.
Yes.
My lord,
I am acting for the administrator.
my lord, just now, my lord, I got the PPO, my lord.
Very good.
On that ground, my lord. And another point is, my lord, the chairman of the minister resigned from the chair, my lord. Kindly leave be granted. Administrator have already been appointed. Administrator made the party respondent, my lord.
Learned counsel for the
Complied with my lord. So for my
So only PPO, my lord. My lord, after consultation with my client, my lord, whether that PPO is rightly or wrongly issued.
that is my lord.
Today, my lord.
That will be a case cause of action.
rightly issued, wrongly issued.
Yes, my lord.
It's not my concern.
Yes,
you
my
have
lord.
to,
My lord.
sir, you have to file a separate petition if the PPO has been wrongly issued.
Yes,
All right.
I'm grateful.
As
to
far
Lord.
as the compliance of this,
Yes,
it
I'm
has
grateful
been
to
done.
lordship.
Deeply obliged, my lord.
Learned counsel for the
As per your lordship order
Respondent.
dated 16 September.
states that the directions passed by this court has been duly complied with. The PPO has been, give me the PPO. The Directorate of Pension, Provident Fund and Group Insurance has issued the PPO dated 17 July 2026. Full stop. In view of the same, nothing survives in the present petition. The same is disposed of in terms of the compliance done by the respondent.
No, my lord.
Obliged, my
My lord, can leave be granted to administrative party because administrator is the disbursing authority, my lord. No amount has yet been paid till now. Only PPO just issue, my lord.
The PPO issuance of PPO, my lord, the subsequent event.
But their part,
certainly
their
is the
part,
disbursement of
their
the payment.
submission, their part complied with, my lord. But administrators part of the disbursing authority, my lord.
Then I humbly leave it to you.
Once the PPO is issued, my lord, he is definitely get the benefits. My lord.
Not a single amount, my lord, was disbursed still now.
But PPO has been issued only on 17th of July, my lord.
All right. Learned counsel for the petitioner seeks and is granted liberty to add the administrator of the municipality as a party respondent to the present proceedings. The same shall be done within a period of 2 weeks. List this matter on 7th.
On 7th. Yes. My lord, in the meantime, supplementary PPO has been issued wrongly, my lord.
If it is issued wrongly,
Yes,
file a writ petition.
File?
A writ petition.
Deeply obliged.
नहीं पहला रहने दो
That please.
वो डाल दो सिर्फ उसमें वो
Hey,
डाल
PPO to
दो
okay.
सिर्फ इतना लिख दो you appear for the department of
For the director of local bodies and department of contender number 3, my lord.
number 3 has states that she has issued the PPO dated so and
PPO was issued by DPPG, my lord, after director of.
who appears for that? You appear for
I am the director of pension and provision.
your respond number?
Respondent number?
2.
Contender number?
Contender number 2 states that the PPO has been duly issued in compliance of the order dated so and so. Full stop. उसके बाद कहता है learned counsel for the
Your lordship's direction, my lord, was upon me to complete all the procedure, my lord, that I have done. Subsequently, DPPG, Director of Pension Provident Fund and Gratuity.
now ensure that the money is also released
Yes, my lord, it will be released, my lord.
Yes, ma'am.
It will be, my lord.
on the 7th.
Deeply obliged, my lord.
Definitely.
Administrator and the party respondent. List on 7th.
I'm grateful to you. এই ফাইলটা এখন দিন না ফাইলটা এখন দিন আমি করে দিচ্ছি কষ্ট এই একটাই কপি এই একটা পিপিওর কপি দিন না মানে
It's all right.
তো ওদের কপি ওদের দেওয়া petitioner আমরা
But I'm for the petitioner. My lord, affidavit of service, your lordship directed me to serve once again.
Yeah, here.
Therefore, the contender number 2 and 3,
We are not getting the PPO.
In case of
Field
item
it.
number 3, my lord, I am appealing for director of local bodies, my lord. My lord, after recasting of panel, my lord, yesterday I have received the information. Still now I have not get the brief, my lord. But I have talked to the authority. They said that appeal has been prepared. One appeal has been prepared in case of Dilip Hari. Match to 167.
I'll call your director local bodies. Is there a stay?
No, my lord, there is.
Then I am not concerned with any appeals. I'm not concerned with any of the appeals which are filed by you. I want compliance of the order. Pay their retirement benefits.
Kindly give me 2 weeks time, my lord. Because
I have already given a lot of time. Do you understand what kind of cases you're dealing with? You're not doing a charity to them. They're entitled to this payment. The way the government comes as if you're doing some charity to them. These are people who have served you. I'll attach the bank account of your director.
Kindly, my lord.
And his salary also.
Kindly, my lord.
Come back on the 7th with the compliance affidavit. Learned counsel for the... You appear for?
Director of local in item number 3.
Yes.
Item contender 1.
The alleged seeks and is granted states that he has been newly engaged on behalf of the state. He seeks and is granted 2 weeks time to file his compliance affidavit. List on 7th. Change your attitude as if you are doing some charity to these people.
So far, contender numbers 2 and 3, they are the erstwhile chairman of the municipality. We have done our job within the stipulated time as prescribed by your laws.
You have filed your compliance affidavit.
This matters we have not. Similarly, eight matters, other matters are there. In
Yes.
those matters we have filed.
They have not filed the compliance report. Before your lordship, my lord, they have not filed the compliance report till date.
In this matter, why you have not filed your compliance?
In this matter, probably there is no direction.
What do you mean no direction? File दिखाना एक मिनट. What do you mean no direction? Contender has to file their report.
Now, 8 matters we have filed. Similarly situated matters. Those have been fixed in the month of.
File in this also.
No, we shall file. Item.
And here you are in 3.
2 and 3.
2 and 3. 3 and 4, not 2 and 3.
My lord, order dated 2nd April 2026, there is a direction.
2 and 3.
Learned counsel for the alleged contender number
2 and 3.
2 and 3 seeks and is granted 2 weeks time to file his compliance affidavit. List on 7th. Let come on the 7th. File your, make them payment.
Well,
enough is enough. एक तीन एक तो आइटम 1 विच कंटेंट में 1 है और ये 2 और 3 दोनों फाइल Five.
Number 5.
Lord, I appear for the contempt.
Yes.
It is a case of sanction of a plan.
Yes, Mr. Mukherjee.
At one point of time, this area, the mother premises, there was a pond. But today, as per the report I have received, there is no pond existing today. The assessment clearance has been given, environment, heritage also clearance has been given. The file is now lying with the survey department. If your lordship is kind enough, I beseech your lordship, if your lordship is kind enough, grants me some more time. And moreover, I told my learned friend, today the corporation does not exist. That is member mayor in council, because no elected member is there. Mayor has given his resignation and all the elected councillors have given their resignation. Even after I process the entire case file, it has to be placed in terms of the law before the member mayor in council, and they cannot put their signature till it is elected. So it is going to take some time. With those submission, my lord, with folded hand, I say, my lord, kindly give some time, not 1 or 2 months, my lord, something more than that, because the election would be sometimes, as I understand, in the month of October or so.
KMC, Mr. Biswajit Mukherjee states that since the corporation has been dissolved, what do we say? That since the mayor in council,
yes, they are
no longer in existence.
There is no meeting. Immediately after the election, they have resigned.
So just hear this. Since the mayor in council is no longer in existence due to the resignation of the mayor as well as the other council members. Other councillors. No decision can be taken by the mayor in council.
Because the plan case after regular has to be placed before the member mayor in council.
Till the regular mayor in council is put in place.
Grateful, mother.
Full stop. In view of this, he prays for an adjournment to file his compliance affidavit. Let this matter be listed after 12 weeks.
I'm thankful to my learned friend. He
understands.
Practical difficulty he appreciates.
Absolutely. 12 weeks. After 12 weeks, we'll see.
Grateful, mother.
I'll give a date, Mr.
Yes, mother. Mother gives it in the after the puja vacation.
After puja vacation?
Yes, mother.
Puja ke baad, keep it on 2nd December.
Grateful.
Your Lordship, in item number 6, I have tried to serve the contempt petition upon the contemner, but Your Lordship, it has been returned as refused. Your Lordship, it has been affidavit of service and original envelope. The remark as refused.
Who did you serve upon?
Your Lordship, the chairperson of the Hooghly Chinsura municipality. And as per the State Urban Development Authority Board, he still is a chairperson, Your Lordship.
Are they still there or they have resigned?
He is still there. As per the State Authority Development Authority website, there's the list of the.
Don't go on the website. Who
This is
makes the
updated on
changes
21st July, Your Lordship, just 1 day ago. I have verified that from the website, Your Lordship.
I don't rely on the websites. They hardly update. Mr. Any idea if these municipalities, the chairman still exist or they have all changed? This is Chinsura.
Hooghly Chinsura municipality. No, what the website?
You don't rely on the website.
Yes, Your Lordship.
Website. Do they even change the websites?
So many experiments of different municipalities. Huge number of municipalities.
They all resigned. My court staff says that website you're talking about. They are more of informed than you are. And then you want compliance of the order. Find the new people. The learned counsel for the petitioner seeks and is granted liberty to add, to implead the newly appointed, what is it, administrator, member, what?
Administrator, Your Lordship.
Find out.
Yes, Your Lordship.
Come back on 7th. Not
Yes,
today. Keep this on 7th. Come back with proper instructions.
Yes, Lordship.
You want compliance of the order, you don't know any homework.
Yes, Lordship.
You are relying on the website. Send your client.
Yes, Your Lordship. I will send.
Give it back. I'm sure your client lives in this area. That's why he wants compliance.
Your Lordship, I will take instruction from my client by sending him the.
Find out the
municipality.
The name of the administrator, the
Maximum municipality. Chuchura is also there.
Number 7.
Wait for your lordship, my lord. My lord, pursuant to your lordship's direction, my lord, the copy was served, and my lord, the order has already been complied with. It has been communicated to us, my lord. Demolition order has already been passed, my lord. That is 2nd July, my lord, memo was issued to my client.
So we can dispose it off, Mr.
Yes,
Maiti.
The only difficulty is Mr. Shondipan Banerjee is appearing for Howrah Municipal Corporation in this matter. His mother expired day before yesterday.
My condolences for him, but we'll dispose it off, or you want?
Well, kindly keep it because I am not in the panel of Howrah Municipal.
All right.
Not sure. Not sure.
Learned counsel for the petitioner states that
let the compliance report be kept with the record.
the order has been duly complied with. He does not wish to pursue the present writ petition anymore. The present petition is dismissed as withdrawn. Compliance affidavit is taken on.
Deep lowest.
I'm good.
Number 8.
My lord, in this matter, I'm on behalf of the petitioner, my lord. My lord.
Yes, madam, tell me.
My lord, on 26/9/2025, your lordship had passed a judgment in WPA 26/887/2024. The judgment starts from page number 12.
Yes.
My lord, after working conscientiously for long drawn years, the petitioner was not given any return benefits.
Have you served upon the other side?
No, my lord.
Then you have to do that service.
Yes, my lord.
And only compliance
today
can be done.
came for the first time.
The take down. The petitioner alleges
non-compliance / willful disobedience of the order passed by this court in dated 26/9/2025 in WPA number 26887 of 2024. Full stop. Let compliance affidavit be filed within a period of 4 weeks. Affidavit let the matter be listed on after 4 weeks ago. 28th August 28th. नहीं एक डेट चूज किया ना हमने 14th किया ना 14th August.
14th August. Deeply obliged, my lord.
Item number 9.
Hey, please, my lord, I am appearing for the petitioner, my lord. My lord, this is my affidavit of service.
Yes, Mr. Nayak.
Lordship, I affidavit. This is my affidavit, not on compliance.
Complied, madam?
Not completely.
No.
My lord's
My lord,
last way the matter was taken up.
Yes.
But we submitted that special officer has passed an order for demolition, and we are determined to demolish it. Date is fixed up. My lord, on that, before that, my lord, just taking action. They have prepared an appeal, PT appeal.
Very
and
good.
My lord, they have shown the date, the 27th.
my lord, that
Date.
has been
This
dismissed
is
for
one of the-
default.
This is one of the point, because 27th of July is the date for final hearing. The order review. This is
What happened in the appeal? Has the order been stayed?
No.
Then what is the
Final,
point?
final hearing. This is number one.
We are not
Number two,
concerned. If the order is stayed, tell me fast so that I can dispose it off.
no. Some more time to be given.
My lord, I will show
No,
you
more time to be
pages.
given. We are determined to get it
You
done.
show me
because
5
all-
pages, I'll hear you. Now tell me.
My lord, kindly sees page number 28. That is the special officer's order.
Page number 28.
This is the evidence compliance.
Mr. Nayak, I heard you. Now let me.
My lord, that was passed in way back 2019.
All right.
Thereafter, my lord, kindly sees page number 30. That is the before the appellate tribunal, my lord. Again, my lord, order dated page number 30. Order dated 31st January 2025. Kindly sees, my lord, dismissed for default. And my lord, this is annexed in their report, which they had filed before your lordship at the time of writ petition hearing. My lord would see the report at page number 25, my lord. It is since, my lord, what has happened, your lordship was extremely lenient and your lordship had directed that you give me a time. When do you want to go and execute this court's order? They had filed this report. They have scheduled their time that they will come on 23rd and 24th of September 2025.
Right.
Thereafter, your lordship kindly sees page number 24, your lordship order. Page number 24, my lord. Premises in question as scheduled by them, that is the KMC, on 23rd and 24th of September 2025. With the above direction, the present writ petition is disposed of. But after special officer's order, that order being challenged before the appellate tribunal, that being dismissed for default, thereafter coming before this honorable court, your lordship passing a direction for demolition. Thereafter, my lord, again they are seeking time.
No, we have not prepared an appeal. We want to get our order executed. We are the corporation who passed this order.
Kindly seize, my lord.
For 1 year, you have done nothing. Let the commissioner come and explain why he is not complying with you.
My lord, only one thing, lordship, kindly appreciate.
And my lord would also see the reminder notice which I had sent them. That my lord would find at page number 31, 39 and 60.
What I am
3
always,
notices.
Draw contempt against him, the commissioner. We'll see that he.
This is our order.
Two matters they should go to, they should be taken to task.
Well, this is our order.
Very
My
good,
lord,
your order. I'm asking you to do your own work.
yes, we shall do it.
You're
We
not
are-
doing it.
We are determined to do it. Give some more time because there is
Sir,
no board.
you have taken
Now-
time for
now,
more than a
lordship,
year.
Now, lordship, there is no board at
You
all.
have taken more than 2 years actually.
Lord, time to time, lordship,
When-
difficulties. Since we
You
fix
show me the time to time action which you have taken.
My lord, September we fix the time. Lordship, kindly appreciate. This is our time. Now,
When was, first of all,
Lord, 1 second, kindly allow me, lordship. Entire building is, my lord, completely occupied. My lord, police,
not concerned, Mr. Nayak.
police, my lord, police failed to
I am
provide
not-
sufficient force.
I am not concerned. Where's the compliance affidavit?
My lord, kindly give us 2 weeks time only.
Mr. Nayak, I will not give you 1 day also.
Only 1 week, lordship.
No,
Let
you
me
have
come up with
already
this
taken time.
observation.
You have been taking time.
No, I have not
You
taken.
have
No,
taken 4 weeks time, Mr. Nayak, on
Lord,
12th of June.
That's the first date, lordship. That's the first.
So what? You have done
I
nothing.
appeared and blood.
You have done nothing. In 4 weeks also,
Take down.
But I deeply
The
object, Lordship,
petitioner
because
had
one
preferred
one
the
week
present
time,
contempt
Lordship.
petition alleging
Well, 1 week. Lordship.
non-compliance with the order passed by this court dated 22/9/2025 in WPA number 23354 of 2023. Full stop. The respondent had filed a report before the writ court indicating that unauthorized construction shall be removed by the respondent corporation on 23/9/2025 and 24/9/2025 as per the scheduled program fixed by the respondent corporation. Full stop. Since the respondent failed to take any action as per the undertaking given to this court, and as recorded in the order dated 22/9/2025, the petitioner had preferred the present contempt petition. Full stop. The present contempt petition was listed on 12/6/2026. Full stop. This court had granted 4 weeks time to the respondent to file his compliance affidavit. Full stop. Till date, no action has been taken by the.
Lord, we have filed our compliance report, Lordship. Kindly take it on record.
Where's the compliance affidavit?
Yes.
This one?
There you have explained, my Lord, in different paragraphs also.
That is
Paragraph.
not compliance,
One
my lord,
second.
with deepest respect.
Where we are saying, my Lord, up to that we have explained our conduct.
The
Paragraph
respondent
3, Lordship.
had filed a compliance report.
In paragraph 3, we have explained, my Lord, what is the difficulties. And I want, my
It
Lord,
is
some more
stated
time.
by the respondent in the compliance report
That was my Lord's order, so we had to comply with it.
that they made
Lot of constraints are there, my Lord. Entire building is
wherein
occupied.
it is stated that due to puja holidays in the year 2025 and the subsequent assembly elections, adequate police force was not made available. The report further indicates that due to non-availability of trained and specialized worker for demolition work, the order of the High Court could not be complied with. It is further noted in the report that the private respondent had moved the BT Building Tribunal by filing appeal number 119 of 2023, which was dismissed.
It is fixed on 27th of July. Final hearing. May place the order. I'll have a look to this, my Lord.
Which was dismissed for default. Full stop. Though subsequently, the report further indicates was filed and was dismissed. Full stop. The report further indicates that the respondent came to know that BT appeal number 119 of 2023 is fixed on 27/7/2026. Though there is no order of stay by the building tribunal. Full stop.
I pray some more time, Lordship. Kindly allow us to have it done.
Full stop. This court notes the sorry state of affairs in the Calcutta Municipal Corporation, whereby the orders passed by this court are not being complied with on one pretext or the other. The
corporation itself had fixed the dates for demolition on 23/9/2025 and 24/9/2025. Almost a year has gone by, but the corporation has failed to comply with failed to comply on his own undertaking given to this court by taking any action for the unauthorized construction. Full stop. The flimsy ground on which the corporation is taking support is that the police authorities have failed to provide assistance, though the affidavit does not indicate any of the letters which have been written to the police authorities whereby the police has refused to cooperate with the respondent Calcutta Municipal Corporation. Full stop. It is surprising to note that for the past 1 year, the corporation is unable to seek adequate police assistance to.
My lord, once again, I'm very sorry to intervene, Lordship. Can I have a look?
Please don't. Please don't. Please don't. To carry out its own orders. Full stop. This dismal state of affairs in the corporation shall be brought to the notice of the commissioner, who shall file an affidavit of compliance on the next date, who shall himself file the affidavit of compliance on the next date. List on give it on 7th within a period of 2 weeks.
When, Lordship, excuse me.
Within 2 weeks, he'll file a compliance affidavit. The commissioner will file a compliance affidavit.
Lordship,
and let's see what he has to say.
One indulgence, Lordship, can I have a look at this? It is.
No, I will not. It's not on record.
Police also requested not to implement this because we are not in.
Sorry,
in
sir.
writing, they have said so.
My lord, may I
We'll take them to task. You file it in an affidavit, we'll take them to task.
That's your Lordship.
My lord, may I only get a copy of their
Yes.
Give a copy.
Yes. I'm giving here and now.
DPO.
But I have submitted. এটা একটু সই করে দেবেন না অর্ডারে গেল না তো গ্রেটফুল লর্ডশিপ
Item number 10.
I am for the petition.
I'm obliged to lords.
But I have served. Service is given. Your Lordship's order at page 9, my lord.
Mr. Tulsidas, probably the municipalities have undergone a huge change.
There is no change.
No change?
No change. No
Then
change.
who's the concerned person?
But the chairman of Tahirpur Notified Area Authority, the contemner hearing, my lord.
Yes. Who did someone appear last time?
Last time, no. Yes, your Lordship directed served notice, my lord. I have served notice upon them, upon the contemner, my lord, hearing.
Take down. Affidavit of service taken on record. Despite service, none appears on behalf of the. This is Tahirpur.
Yes, Tahirpur Notified Area Authority.
Which container number?
One container, my lord. This is one container.
No, this. No, Mr. Tulsidas, there's more. Who are the contemners here?
Uttamananda Das, page 3, my lord. Chairman, Tahirpur Notified Area Authority. Page 3.
Chairman is respond number 5.
No, my contempt. Last page 3, my lord. Can you see? Contempt application, page 3.
Yes, contempt petition, page 1, 2, number 5, respond number 5. What are you saying?
Respond about contempt number 1, 3, my last. You can see.
Clarify.
Page 3, my lord.
This is contender number 1. Full stop. This court,
Well, operative part of the order is page 23, 15. Paragraph 23.
one more opportunity is granted to the contender number 1 to comply with the directions passed by this court while it's order dated 12/6/2026 within a period of 3 weeks. The court will be constrained to issue non-bailable warrants against the contender if he doesn't comply with the orders passed by this court on the next date. This court will be constrained to issue non-bailable warrant. We'll issue warrant against him. We'll get him arrested. Let's see what to do. Today, 14th. 14th August.
August.
14 is I am for the petition.
No, no.
हफ्ते हो जाएंगे
No, no. 14 days.
I'm sorry.
Same contender, same matter, same issue.
Same order करो.
Same respondent. Go ahead. Mark.
12, my lord, I am appearing for the petitioner, my lord. My lord, serve the contemners, my lord.
Yes.
My lord, the municipality has contested the writ petition, my lord. They have the knowledge of the order, my lord. Still, they have not complied, my lord. Regarding the payment of retirement benefits, my lord.
Who's for the which corporation is this?
My lord, this is Titagarh municipality, my lord.
Titagarh.
Titagarh municipality, my lord. Okay.
Are they still there or administrator has been appointed? Find out.
My lord, their correction has been made, my lord. On the last occasion, my lord has passed an order, my lord. According to that, my lord.
Have you served them?
Yes, my lord. They have been
Newly added party?
Yes,
Where's-
my lord. Chairman, my lord. Last order, my lord, has directed and I've corrected the name, my lord, and it will serve.
So now the administrator has taken over. Yadav Surebam.
Administrator, my lord, Yadav Suryavan Achelal, my lord. He has been added, my lord. In place of, my lord, the chairman, my lord. And executive officer is there, my lord, already there. The administrator has been served, my lord.
Take on despite service. None appears for the newly added respondent, Mr. Yadav Surebam Achelal. Yeah. Page 5. Spelling through different. ACH ACHCHHELAL. Spelling देख लेना. वो जो order किया था, last opportunity to file compliance affidavit or this court will be constrained to issue non-bailable warrant to the तेरा बुला तो ले. Issue rule. They don't come, nothing will happen. Come is that. 14th.
Grateful, my lord.
Particularly big to appear on behalf of the petitioner. My lord, this is a recalling,
number 5, ma'am.
recalling application, my lord, relating to, my lord, the municipal authority of Haldia municipality.
Yes.
My lord, what happened? Lordship, kindly see, my lord, the order. My lord, there is a protracted litigation. In earlier round of litigation, there is a direction to the municipal authority to come to a conclusion. My lord, I have taken a stall, advertisement being published.
My lord, before starting my lord argument, my lord, only I appeared in the matter. I want to come physically, my lord. If your lordship give it to the past, my lord, that not today only. If you, I have done this matter earlier, my lord. I am requesting.
Seventh.
I am so
Affidavit of service, may kindly.
Affidavit of service taken
no,
on
no,
record.
I have received copy. I have received copy.
Let this
My
matter
lord,
be
as a
listed on 7th August.
Deeply.
Number 5, ma'am.
and deeply.
Number 14.
Item number 14, my lord.
Before my learned
I am
senior
for
friend
the-
start, may I submit one thing? Mr. Shondipan Banerjee is
Yes.
appearing in this matter. His mother has
Yes,
expired
sir.
on Monday.
Learned, take down. Proxy counsel so appears and states that Mr. Sandeepan Banerjee has suffered a demise in his family. He prays for an adjournment. Let this matter be adjourned to. We'll have it on 14th August.
Okay.
I'm good.
Deeply obliged. And I'm sorry, my lord. That time I instead of following.